Hey guys, tonight we're stepping into a world where justice didn't need courtrooms, where your word was worth more than any lawyer's argument, and where the punishment for murder might just be writing a really expensive check. You are about to discover how the Vikingsies, those axe-wielding, ship-sailing Norsemen, managed to run surprisingly functional societies without judges in wigs or gavels echoing through marble halls. Picture yourself standing in a muddy field somewhere in 10th century Iceland, surrounded by bearded men who've travelled days just to argue about a stolen goat, and you'll realise that Viking law was equal parts brilliant, bizarre, and absolutely ruthless. Fair warning, you probably won't survive long in this legal system if you can't back up your claims with either a small army of friends or a willingness to fight to the death. So, before you get comfortable, take a moment to like the video and subscribe, but only if you genuinely enjoy what I do here. And hey, drop a comment letting me know where you're watching from and what time it is in your corner of the world. I love seeing how far these bedtime stories travel. Now, dim the lights, maybe turn on a fan for that soft background hum, and let's ease into tonight's journey together. You're living in a world without police stations, without prisons in the way we understand them, and definitely without the 1800 number you can call when your neighbour's sheep keep wandering onto your barley field. Viking Age, Scandinavia rally 700 to 1100, CE operated on a completely different frequency when it came to maintaining order. Instead of a centralized legal system with professional judges and enforcement officers, Norse communities relied on something far more personal: your reputation, your family connections, and your ability to convince others that you're telling the truth. The foundation of Viking justice rested on collective memory and social pressure. You're not dealing with anonymous bureaucrats interpreting written codes, you're facing your neighbors, people who've known your family for generations, who remember that time your grandfather got caught cheating at dice, and who will absolutely hold it against you if you try to weasel out of your obligations. Historians describe this as a stateless society model, where law enforcement wasn't the government's job because, frankly, there wasn't much government to speak of. Kings existed, sure, but their power was limited, especially in places like Iceland, where chieftains operated more like influential mafia dons than traditional rulers. The genius of this system lay in its flexibility. You're not waiting months for a trial date or navigating endless appeals. When conflict erupts, and oh, it will erupt because Vikings were passionate about their honor, you have multiple pathways to resolution. You can negotiate compensation directly with the offended party. You can gather your friends and family to publicly swear oaths supporting your version of events. You can challenge your accuser to combat. You can even accept exile if things get really messy. The key is that you're an active participant in your own legal fate, not a passive defendant waiting for someone else to decide your future. What's wild is how this approach actually prevented many conflicts from spiraling into endless violence. Historians still argue whether Viking law was primarily punitive or restorative, but the evidence suggests it leaned heavily toward the latter. If you kill someone, the goal isn't necessarily to kill you back, it's to compensate the victim's family enough that they'll agree not to hunt you down like a wounded elk. This might sound cynical, like putting a price tag on human life, but in a society without prisons, where every hand was needed for farming, fishing, and defending against raids, executing people left and right wasn't exactly practical. The system also recognized that not all crimes were equal. You're dealing with gradations of offense that made sense to people who lived close to the bone. Accidentally killing someone during a drunken brawl at a feast. Bad, but forgivable if you admit it immediately and offer appropriate compensation. Secretly murdering someone and hiding the body? That's the kind of cowardly, dishonorable behavior that could get you outlawed, literally declared outside the law's protection, meaning anyone could kill you without consequences. The Vikings were big on transparency. They respected a good, honest murder more than sneaky treachery. One quirky aspect that doesn't get enough attention: the legal system was fundamentally oral. You're not reading contracts or filing paperwork. Everything depends on human memory, on witnesses who can recite exactly what was said at which gathering, on the ability to memorize complex genealogies proving your right to inherit that disputed piece of land. This made eloquent speech a superpower. If you could craft the right argument, make the crowd laugh at your opponent's expense, or recite your ancestry back 7 generations without stumbling, you had a real advantage. It's like if modern court cases were decided by rap battles. The absence of formal courts also meant justice was incredibly localized. You're not dealing with universal standards applied equally across vast territories. What's acceptable in one valley might get you ostracized in the next. This created a patchwork of customs and precedents, transmitted through traveling law speakers sessionally, human legal databases, who memorized vast bodies of traditional law and recited them at gatherings. Imagine being that guy, the walking encyclopedia of, remember when Bjorn's uncle settled a land dispute with 3 cows and a silver arm ring? Your brain was the legal library. You're walking uphill toward a flat clearing where hundreds of people have already gathered, their tents forming a temporary village around the meeting ground. This is the Thingend. No, that's not a typo or some cryptic reference. It's literally what they called their outdoor parliament. The word comes from the Old Norse ding, meaning assembly or meeting, and it's where the bulk of Viking legal drama unfolded. Several times a year, depending on the region, free men, we'll get to the free men qualifier in a moment, would travel from their farms and villages to attend these gatherings, which served as combination courtroom, legislative session, trade fair, and honestly, the biggest social event of the season. You're standing in a natural amphitheatre of sorts, maybe a hillside with good acoustics, or a flat field near a prominent rock formation that serves as a landmark. The location matters because these things don't happen in fancy buildings. You're outdoors, vulnerable to rain, wind, and the occasional curious cow wandering through proceedings. The most famous thing was Iceland's Althing, established around 930 CE at Ingvellir, a dramatic rift valley where the North American and Eurasian tectonic plates literally pull apart. Geologists love it. Vikings just thought it looked impressive and had decent camping spots. The thing operates on a schedule that respects the agricultural calendar. You can't exactly abandon your farm during planting or harvest season, so these assemblies typically happen in early summer or early autumn when you can spare a few weeks away from home. Yes, weeks. You're not driving in for an afternoon court appearance. You're committing to what's essentially a legal festival. People bring their families, their goods to trade, their grievances to air, and enough mead to ensure things stay interesting. Historians still argue whether the heavy drinking enhanced or undermined the legal proceedings, but eyewitness accounts suggest it did both, often simultaneously. Here's who gets to participate. Free men who own land or hold a certain status in their community. You're out of luck if you're a slave, a woman with some exceptions we'll explore later, or too young to be considered responsible for your own actions. This wasn't democracy in the modern sense. It was more like a council of property-owning stakeholders who all had something to lose if chaos broke out. The typical thing might draw anywhere from a few dozen to several thousand attendees, depending on its importance. Iceland's Althing was the big show, attracting participants from across the entire island, while local things handled smaller regional matters. The proceedings follow a ritualized structure. You're watching as the law speaker, remember that human legal encyclopedia, stands on a prominent rock or raised platform and recites portions of the law from memory. This happens at the beginning of the thing and serves multiple purposes. It reminds everyone of the rules. It demonstrates the law speaker's competence. If he forgets major sections, you've got problems. And it establishes a baseline for the disputes about to unfold. The law speaker doesn't judge cases himself. He's more like a reference manual you can consult when arguments erupt about what the law actually says. Next come the cases, presented in a specific order based on severity and social importance. You're waiting your turn if you've got a complaint about a property boundary, while the guy whose brother was murdered gets priority. Each case involves the plaintiff presenting their grievance, witnesses offering their testimony, and the defendant responding. The crowd isn't just passively watching, they're the jury, judge, and sometimes the enforcement mechanism. If enough respected men vocally support one side, that's essentially the verdict. You're swaying public opinion through eloquence, emotional appeals, displays of evidence, and yes, occasionally through thinly veiled threats about what might happen if the verdict goes the wrong way. One quirky aspect that catches modern people off guard, dueling could be proposed right there at the thing. You're arguing your case. It's not going well, and you might suddenly challenge your opponent to homgang. We'll dive deep into that in the next section. The Thing Assembly doesn't prevent this. It actually provides a legitimate framework for violence to settle disputes. It's like if modern courts let you substitute jury deliberation with a cage match. The social dimensions of the thing were just as important as the legal ones. You're networking, arranging marriages, making trade deals, hearing news from distant regions, and generally participating in the wider Norse world. For people who spent most of the year isolated on remote farms, this was your chance to feel connected to something larger. The evenings dissolved into feasting, storytelling, and the kind of drunken bonding that either forged lifelong alliances or created next year's court cases. Some things developed reputations as rowdy affairs where more violence happened in the camps than got resolved in the proceedings, which seems counterproductive, but Vikings never claimed to be paragons of consistency. The Thing also served as a legislative body, though making laws looked different than modern parliaments. You're not electing representatives or debating bills, you're collectively agreeing on modifications to existing customs, usually in response to new situations. Maybe long-distance trade has created disputes that old laws don't cover, so the Assembly agrees on new standards. Maybe someone's innovative crime requires a new category of punishment. The law evolved organically through consensus, not through some king's decree, though kings sometimes tried to influence proceedings by showing up with armed supporters, which had a way of focusing minds. What's remarkable is how effective this seemingly chaotic system was at maintaining social order. You're relying entirely on shame, reputation, and community pressure to enforce decisions. There's no police force to arrest someone who refuses to pay the compensation they owe. Instead, if you're judged guilty and refuse to comply, you risk outlawry, and that's a fate so terrifying that most people chose compliance. The Thing worked because everyone involved had a stake in making it work. If legal proceedings broke down into constant violence, everyone's property and family were at risk. Self-interest aligned beautifully with social stability. You're watching two men strip off their outer tunics and step onto a specially prepared piece of ground, and you realize with a sinking feeling that this legal dispute is about to get extremely physical. Welcome to Holmgang, the Viking answer to the age-old question, how do we resolve this argument when nobody can agree on the facts? The solution? Let the gods decide through combat. The word Holmgang literally means island going because these duels were traditionally fought on small islands, presumably to prevent either participant from running away mid-fight, though honestly, if you're scared enough to flee, a little water probably won't stop you. The rules of Holmgang were surprisingly specific for something that essentially boiled down to hit each other until someone wins. You're standing within a marked area, usually a cloak or hide spread on the ground measuring about 10 feet square. Step outside that boundary and you're considered a coward, which in Viking society was worse than being a corpse. Each duelist gets 3 shieldsies. 3, because Vikings understood that shields break when you're smashing them with axes and swords. Once your 3rd shield splinters, you're fighting with just your weapon and whatever protective gear you're wearing, which wasn't much. Chainmail was expensive. Most participants wore leather and hope. Here's where it gets interesting. Holmgang wasn't a fight to the death, though it certainly could end that way. You're aiming for first blood. In many cases, the first person to bleed onto the cloak loses the dispute. This made dueling accessible to people who weren't necessarily master warriors. Sure, the guy who raided England twice and has arms like tree trunks has an advantage, but even an average farmer might get lucky with a quick slash. Some holmgang matches were fought until one participant yielded, either by stepping off the cloak or verbally conceding defeat. Death was always a possibility, hovering over the proceedings like an uninvited guest who might show up and ruin everything. The truly quirky aspect? You could hire a champion to fight in your place. You're a wealthy merchant with zero combat skills, accused of cheating in a trade deal. No problem, pay a professional duelist to represent you. This created a whole cottage industry of warriors for hire who made their living fighting other people's legal battles. Historians still argue whether this undermined the supposed fairness of holmgang or simply represented practical adaptation to reality. After all, if the gods were truly deciding the outcome, did it matter who held the sword? The market seemed to think not, and going rates for champions varied based on their win-loss records. You're probably wondering what kinds of disputes led to holmgang. The answer is distressingly many. Insults to honor, holmgang. Property disagreements when witnesses contradicted each other, holmgang. Accusations of cowardice, theft, or disrespecting someone's ancestors, holmgang, 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 holmgang. It was the legal equivalent of, let's take this outside, except formalized with witnesses, rules, and the understanding that whatever happened was legally binding. Some sources suggest that challenging someone to holmgang could actually be a bullying tactic. You were known as a dangerous fighter. You might accuse people of minor offenses just to intimidate them into settling on your terms. The sacred aspects of holmgang gave it legitimacy beyond mere violence. You're not just brawling in a tavern, you're participating in a ritual ordeal where divine judgment would supposedly favor the righteous. Before fighting, participants often invoked their gods Thor for strength, Odin for cunning in battle. The cloak or hide marking the dueling ground had ritual significance, creating a sacred space where normal rules were suspended. Blood spilled within that boundary carried different weight than blood spilled in casual violence. This spiritual dimension made holmgang outcomes harder to dispute. If the gods favored your opponent, well, who were you to argue with cosmic justice? Women could technically challenge men to holmgang, though it was rare and sources disagree about how often it actually happened. You're a Norse woman with a grievance, you probably hired a champion rather than stepping into the square yourself, not because women couldn't fight. Plenty of evidence suggests some did, but because the social consequences of a woman losing a duel were harsher than for a man. A defeated male duelist might be shamed, a defeated woman risked permanent loss of status. Still, the sagas mention exceptional women who fought their own battles, which tells us the system had at least theoretical flexibility. The Christian Church really hated holmgang, seeing it as pagan superstition wrapped in violence. As Christianity spread through Scandinavia in the 10th and 11th centuries, you're seeing increased pressure to abandon trial by combat in favor of other dispute resolution methods. Iceland officially banned holmgang in 106 CE, though enforcement was spotty and people kept dueling anyway because old habits die hard, especially when those habits involve axes. The ban didn't eliminate combat as a legal tool, it just pushed it underground or reframed it as mutual combat rather than formal holmgang. Semantics, they matter even to Vikings. One detail that doesn't get enough attention, seconds or assistants, played crucial roles in holmgang. You're not entering that cloak alone, you've got a friend or family member standing by to hand you fresh shields, offer encouragement, and most importantly, verify that your opponent isn't cheating. These seconds also served as witnesses to ensure the loser honored the outcome. If you tried to claim later that you didn't really lose, those witnesses could publicly shame you for lying, which brought us right back to reputation-based enforcement. Everything in Viking law connected back to your standing in the community. The practice eventually faded not just because of Christian opposition, but because centralized royal power made these private combat solutions obsolete. You're living under a king who claims monopoly on legitimate violence, and suddenly your right to challenge your neighbour to a duel looks like a threat to royal authority. By the 12th century, holmgang was mostly a historical curiosity rather than active practice, though its echoes persisted in formal dueling traditions that lasted centuries longer in other forms. Vikings didn't invent trial by combat. It existed in various cultures, but they certainly refined it into an art form that was equal parts legal proceeding and spectator sport. You're standing in the thing assembly watching a man's face drain of colour as the law speaker pronounces the worst sentence possible, full outlawry. His crime might have been murder, arson, serious theft, or perhaps something as seemingly minor as refusing to pay compensation after being judged guilty. Whatever the reason, he's just been erased from society in a way that makes execution look merciful. As an outlaw, you're no longer protected by law. The very word, outlaw, means you're outside the law's protection. Anyone can kill you without consequence. Your property is forfeit. Your family can't help you without risking their own status. You're a ghost, except ghosts at least get to haunt their old homes, and you don't even have that privilege. The Vikings recognized two types of outlawry because they were nothing if not precise about their categories of misery. Lesser outlawry, called feuds, meant exile for 3 years. You're banished from your home region, forbidden from owning property or conducting business there, but you retain legal personhood elsewhere. People in other areas can still trade with you, shelter you, even employ you without penalty. Think of it as a temporary excommunication with geographic boundaries. If you survive the 3 years abroad and behave yourself, you can petition to return and resume normal life. Many outlaws chose to head to Iceland, Greenland, or the Scottish Islands frontier zones where questions about your past didn't get asked too loudly. Full outlawry, skogengra, forest going, was the nuclear option. You're declared an enemy of society itself, stripped of all legal protection anywhere in Norse territories. The sentence was typically perpetual, though in rare cases it could be overturned if circumstances changed dramatically. As a full outlaw, you couldn't own property, make contracts, testify in legal proceedings, or receive shelter from law-abiding people. Anyone who helped you risked becoming an outlaw themselves, which created a terrible isolation. Your own family might love you, but they loved their legal status and property more, and honestly, who could blame them? Here's the truly horrifying part. Killing an outlaw wasn't just legal, it was sometimes encouraged. You're essentially wearing an invisible target on your back at all times. The person who kills you doesn't face punishment. In fact, they might earn social credit for ridding the community of a dangerous element. Some outlaws had bounties placed on their heads, turning their elimination into a profitable side hustle for ambitious warriors. This created a nightmare scenario where you couldn't trust anyone, even apparent allies, who might decide your head was worth more than your friendship. The practical consequences of outlawry meant you were forced into the wilderness forest going. You're living in caves, rough shelters in remote mountains, or dense forests where society's reach didn't extend. Vikings weren't naturomantics. They knew the wild spaces were brutal. You're facing starvation, exposure, wild animals, and the constant psychological toll of isolation. Some outlaws formed bands with other exiles, creating outlaw communities that survived through raiding and theft, which of course only reinforced everyone's opinion that outlaws deserved their fate. It was a vicious cycle with no good exits. What's darkly fascinating is how outlawry served multiple social functions simultaneously. You're removing a dangerous person from society without the finality of execution, which preserved a tiny possibility of redemption while still delivering harsh punishment. It avoided the blood feud complications that execution might trigger after all. The community didn't kill the outlaw, they just stopped protecting him. Whatever happened after that was between him and fate. Historians still argue whether outlawry was more humane than execution or actually crueler, since it prolonged suffering and transformed the condemned into hunted animals. The sagas are full of outlaws who became almost legendary figures. You've got Grettir the Strong, outlawed for 20 years and credited with superhuman strength and endurance. Gisli Surson, who survived 15 years as an outlaw through cunning and occasional help from sympathetic allies willing to risk their own status. These stories probably exaggerated the romance and downplayed the misery. After all, most outlaws died miserably and anonymously, not in dramatic last stands worthy of poetry. But the sagas reveal how outlawry captured the Norse imagination, representing the ultimate test of individual resilience against impossible odds. One quirky loophole: some outlaws technically fulfilled their sentences by dying and being declared dead, but then returned under new identities. You're dead, Olaf the outlaw, but you've reinvented yourself as definitely not Olaf, in a remote settlement where nobody asks too many questions. This worked better in an era without photographs, fingerprints, or social security numbers. If you could grow a different style beard, change your name, and avoid anyone who knew you before, you might successfully ghost yourself back into society. It wasn't common. Most outlaws didn't have the resources or luck to pull it off, but it happened enough that laws eventually addressed the issue. The social dynamics of outlawry created strange situations around property. You're outlawed, so your farm is forfeit, but what if you had a wife and children? The law handled this inconsistently across regions. Sometimes the family retained partial rights, sometimes they lost everything, sometimes it depended on whether the wife divorced you quickly enough to distance herself legally. This created perverse incentives for families to abandon outlawed relatives immediately, not out of lack of love, but pure survival instinct. The system literally forced you to choose between loyalty and everything you owned. Christianity's arrival complicated outlawry because the church taught that all humans deserved certain minimum protections and that killing was sinful even when legal. You're a Christian outlaw, and suddenly some priests are arguing you should receive sanctuary in churches, while others insist the old laws still apply. This theological tension never fully resolved. The church gained power to grant sanctuary in some cases, but outlawry persisted as a legal category well into the Christian era. The Vikings essentially kept the punishment structure but dressed it in new religious clothing, claiming that outlaws were fighting against God's law, not just human society. The psychological terror of outlawry might have been its most effective element. You're not just afraid of death, you're afraid of invisibility, of becoming less than human in others' eyes. Vikings valued reputation and social belonging above almost everything else. To be formally declared outside that circle, to watch people you've known your whole life literally turn their backs on you, must have been devastating. Some outlaws apparently committed suicide rather than face years of hunted existence. Others became so psychologically damaged by the experience that even if they survived to have their sentence lifted, they never fully reintegrated. The punishment didn't just remove you from society, it fundamentally broke who you were. You're probably thinking that outlawry sounds extreme, and you're right. But Vikings understood that declaring someone a walking target wasn't always the best solution, especially when the offence was serious but not unforgivable. Enter Wergild, which is Old Norse for man price, though it covered far more than just whole dead humans. This was the Vikings' ingenious solution to blood feuds. Instead of your family killing my family, who then kills your family, escalating into a multi-generational murder spiral that depopulates entire regions, we just agree on a price. You killed my brother? That'll be 12 milk cows, 3 silver arm rings, and a decent sword. We shake hands. The debt is paid, and nobody else has to die. It's mercenary, it's pragmatic, and honestly, it worked surprisingly well. The system operated on detailed price lists that would make modern insurance adjusters weep with envy. You're not dealing with vague notions of appropriate compensation. Vikings had specific values for every conceivable injury. Kill a free man? The standard wergild in Iceland was typically around 100 ounces of silver, though this varied by region and the victim's social status. Chieftains and important men commanded higher pre-sesame times, double or triple the baseline. Kill a slave? Much cheaper, because slaves were property first and people second. The harsh calculus of wergild reflected social hierarchies with brutal honesty. But here's where it gets delightfully specific. The Vikings didn't just price death, they priced injury with absurd granularity. You're consulting what essentially amounts to a menu of body parts and their associated costs. Lose an eye? That's worth X amount. Lose a hand? Y amount. Lose a finger? Depends which finger. The thumb was worth more than the pinky because it was more functionally important. The old Scandinavian law codes preserved some of these lists, and they're fascinating rabbit holes. A knocked out tooth might cost you a sheep. A broken nose could run you several silver pieces. Permanent scarring on the face. Premium pricing, because you've damaged someone's appearance and therefore their marriage prospects and social standing. The legal texts even covered, well, let's delicately say, masculinity-related injuries. You're a Viking warrior whose manhood gets damaged in a fight, and the compensation is substantial, because the Vikings understood that some injuries struck at the core of a man's identity and future prospects. These weren't just physical prices, they were attempting to compensate for lost honor, lost reproductive capacity, and lost social standing. It's almost touching how the system tried to quantify psychological and social harm alongside physical damage. What's brilliant about wergild is how it channeled the desire for revenge into something productive. You're absolutely furious that someone killed your father, and your first instinct is to grab an axe and settle things the old-fashioned way. But then the elders remind you that if you kill the killer, his family will kill you, and then your family will kill them, and pretty soon there's nobody left to harvest the crops or defend against raids. Wergild offered an off-ramp from the violence highway. It acknowledged your loss, gave it concrete value, and transformed your rage into a debt that could be satisfied without more bloodshed. Payment wasn't always immediate or in full. You're the guilty party, and you've just been assessed a wergild of 150 ounces of silvera fortune you absolutely don't have lying around. The system allowed for payment plans, debt transfers, and creative financing. You might pay part in silver, part in livestock, part in land rights, maybe throw in some high-quality weapons to sweeten the deal. Your extended family often helped cover the cost, which made sense because they'd benefit from avoiding a blood feud. Some payments stretched over years, with installments due at specific things or seasonal gatherings. Default on those payments, though, and you risked outlawry or renewal of the feud. The negotiation process could be as complex as the crime itself. You're attending a settlement meeting where both families gather with their supporters, and the dickering begins. The victim's family inflates the worth of the deceased. He was about to become a wealthy trader, a great warrior, a pillar of the community. Your side downplays his value. Hall was old, sickly, had few prospects. Honestly, you did him a favor. Mediators tried to strike fair balances, consulting precedents from similar cases. Historians still argue whether wergild primarily benefited the wealthy, who could literally buy their way out of murder charges, or whether it democratized justice by giving poor families financial compensation they desperately needed. One quirky aspect, partial responsibility, could mean partial payment. You're involved in a brawl where 3 people ganged up on the victim, and the court determines each of you is 1/3 responsible. You pay 1/3 of the wergild. The math could get complicated when fights involve multiple participants with varying degrees of involvement, who threw the first punch, who landed the killing blow, who just stood around shouting encouragement. Viking legal proceedings sometimes resembled accounting exercises more than moral judgments. The system also recognized accidental versus intentional harm. You're chopping wood and the axe head flies off and kills a passerby. That's still your fault, but the wergild might be reduced because you didn't intend murder. You planned an ambush and killed someone in cold blood. Full price, possibly with additional penalties. Intent mattered. though proving it could be challenging without video evidence or reliable witnesses. This is where those oath helpers we mentioned earlier became crucial. The more people willing to swear you had no murderous intent, the better your chances of reduced compensation. Women and children had their own were-guild values, generally lower than adult-free men, which reflects the unfortunate reality of Viking gender and age hierarchies. You're a woman killed in a raid, and your were-guild might be 2/3 what a man's would be, though high status, women, wives of chieftains or landowners, could command prices equal to or exceeding average men. Children's were-guilds increased with age, presumably because older children represented more years of parental investment and had clearer future value to their families. It's cold calculus, but Vikings weren't sentimental about these matters. The were-guild system eventually declined as centralized royal power grew and kings claimed the right to punish crimes as offenses against the state rather than just private wrongs requiring private compensation. You're living in 12th century Norway, and suddenly the king is arguing that murder isn't just an injury to one family. It's a breach of the king's peace, requiring royal justice and royal penalties. This shift transformed crime from a private debt into a public wrong, laying groundwork for modern criminal law. The Viking approach didn't disappear overnight, but it gradually gave way to systems where the state, not the victim's family, determined punishment. You're sitting in the Thing assembly watching a settlement get finalized, and just when you think the were-guild payment has closed the case, someone mentions the nose clause. Your stomach drops because you realize that even though the financial debt is settled, Viking law sometimes permitted a little extra revenge, the carefully calibrated, legally sanctioned kind that let the injured party express their rage without triggering a whole new cycle of violence. Welcome to the world of mutilation rights, where cutting off someone's nose wasn't assault, it was your legally protected consolation prize. The most famous example involves nasal amputation, hence historians calling it the nose-cutting defense or nose penalty. You're the victim of a serious crime. Maybe someone killed your brother, maybe they seriously injured you or dishonored your family, and while they've paid the were-guild, you're still burning with humiliation and anger. The law in some Norse regions recognized this and gave you permission to track down the offender and slice off their nose, not their ear, not their hand, specifically their nose. Why? Because nose removal was permanently disfiguring and socially devastating without being disabling. You could still work, fight, and function in society. You just looked like a marked criminal for the rest of your life. The brilliance of this system lay in its limitations. You're angry enough to want blood, but the law channels that desire into specific, permitted acts that don't escalate the conflict. Once you've taken the nose, you're done and no further revenge allowed. The other party can't retaliate for the nose cutting because it was legally sanctioned. It's like a pressure release valve that lets enough steam escape to prevent the whole boiler from exploding. The revenge is real, the humiliation is lasting, but the cycle stops there instead of spiraling into generations of tit-for-tat killings. The psychological impact of walking around without a nose was substantial. You're permanently marked as someone who committed a serious offense. Everyone who looks at you knows you did something terrible enough to warrant mutilation. In a society obsessed with honor and reputation, this visible shame was arguably worse than a hidden injury. You couldn't hide it, couldn't minimize it in retellings, couldn't claim the whole thing was exaggerated. Your face literally announced your guilt. Some sources suggest that noseless men struggled to find marriage partners, conduct business, or maintain social standing. The disfigurement became a lifetime sentence even though the actual legal case was closed. But noses weren't the only body parts subject to these specific revenge rules. You're exploring the legal codes and finding provisions for ear cropping, which served similar purposes. In some cases, the law permitted cutting off someone's hand or fingers, not for theft necessarily, but as compensation for specific types of betrayal or dishonor. The key was always proportionality and specificity. The law didn't just say, go mutilate them however you want. It prescribed exactly which body part could be taken, under which circumstances, and with what limitations. Violate those boundaries and you'd suddenly find yourself on the wrong end of a legal complaint. Historians still argue whether these mutilation rites were commonly exercised or mostly theoretical deterrents. The sagas mention nose-cutting incidents, but they're rare enough that we can't be certain whether this was everyday practice or exceptional cases that became memorable stories. It's possible that the mere existence of the legal rite satisfied most people's desire for revenge without actual implementation. You're the injured party, and knowing you could legally disfigure your enemy might be enough psychological satisfaction that you choose not to actually do it. Or maybe people did it all the time and just didn't write it down because it was too mundane to note. The timing and procedure mattered too. You're not allowed to ambush someone randomly 3 years after the crime. There were typically specific windows during which you could exercise your mutilation rites, often immediately after the thing assembly where the weregild was determined. This prevented people from brooding for years and then suddenly showing up for revenge when the other party thought everything was settled. It also ensured witnesses were present, which protected both parties. You performed the mutilation publicly so everyone could confirm you took only what was permitted and nothing more. What's darkly fascinating is how this interacted with the weregild system. You're paying compensation for killing someone, and the victim's family has the right to take your nose afterward. Some savvy negotiators apparently offered additional payment to waive the mutilation, right essentially buying back their nose before losing it. I'll pay you 15 extra ounces of silver if you promise not to disfigure me, became a legitimate negotiating position. The victim's family could accept and walk away richer, or refuse and take the satisfaction of permanent marking. It transformed revenge into another commodity that could be priced and traded. The practice also had gendered dimensions. You're a woman seeking revenge, and the sources are unclear about whether you could personally perform the mutilation or needed a male relative to do it. Some sagas show women demanding that their menfolk execute these revenge rites, turning nose-cutting into a test of family loyalty. If you truly honor your sister's injury, you'll take his nose, that kind of social pressure. Refusing might suggest you were weak or didn't value your female relatives enough, which brought its own shame. Christianity's arrival made these mutilation practices increasingly problematic. You're a Christian missionary trying to convince Vikings that turning the other cheek is superior to cutting off noses, and you're not having much success. The Church generally opposed bodily mutilation for both theological and practical reasons. The human body was God's creation, marking criminals permanently seemed to usurp divine judgment, and honestly, it all seemed barbaric to Christian sensibilities shaped by Roman legal traditions. As Norse societies Christianized, mutilation rites gradually faded, though they persisted in modified forms in some regions well into the medieval period. One quirky detail, some sources suggest that skilled healers could partially reconstruct noses using skin flaps from other parts of the body, yearly plastic surgery essentially. You're a wealthy, noseless man who can afford such treatment, and while the result was never perfect, it might be good enough to reduce the social stigma. This created yet another layer of inequality. Rich criminals could literally buy back their faces, while poor ones wore their shame forever. The Vikings, despite all their talk of honor and valor, were never blind to the power of wealth to smooth over consequences. The nose-cutting defense reveals something essential about Viking legal philosophy. They understood that justice wasn't just about material compensation. You needed emotional satisfaction too, some tangible expression of society's condemnation. Modern legal systems try to provide this through imprisonment and criminal records, public markings of guilt that follow people through background checks and online databases. Vikings just did it more literally, carving justice directly into flesh. Both approaches recognize that victims need to see consequences, to know that wrongs don't go unmarked. The Vikings just had less patience for abstractions and more appreciation for visible, unmistakable proof. You're standing at the thing with a serious accusation hanging over your head. Maybe someone claims you stole their livestock or cheated in a trade deal, or worse. In a modern court, you'd present evidence, receipts, photographs, security footage, forensic analysis. In Viking society, you present people, lots of people. The oath helper system meant that your best defense wasn't physical proof, but social proof, the number and quality of individuals willing to publicly swear that you're telling the truth. Your reputation wasn't an abstract concept, it was a quantifiable asset measured in human bodies standing beside you when everything was on the line. The mechanics were surprisingly formal for a society that handled so much through informal custom. You're required to produce a specific number of oath helpers, called compurgators in legal terminology, who would swear oaths supporting your claim. The number varied based on the severity of the accusation and your social status. Minor offence, maybe you needed 6 oath helpers. Serious crime like murder, you might need 12 or even 24 in some regions. These weren't character witnesses testifying about what they'd observed. They were literally swearing that your version of events was true, staking their own reputation on your honesty. Here's what made the system work. If your oath helpers were later proven to be lying, they faced serious consequences themselves. You're swearing for your neighbour's innocence in a theft case, and then evidence emerges that he was absolutely guilty? Congratulations, you've just destroyed your own credibility. Future legal proceedings would remember that you swore false oaths, making it harder for you to gather oath helpers when you needed them. It was social credit scoring before computers, with your reputation serving as the database that everyone consulted. Some people apparently became so tainted by false oath swearing that they were officially barred from serving as compurgators, which was like being declared legally untrustworthy. The quality of your oath helpers mattered as much as quantity. You're a minor farmer who's managed to gather 12 other minor farmers to swear for you? That's decent. But if you can get even 3 wealthy chieftains or respected elders to vouch for you, that carried more weight than a dozen nobodies. The system explicitly recognized that some people's words were worth more than other meritocracy was not a Viking value. Status, wealth, family connections, and personal reputation all factored into the calculation. It's like if modern courts assigned different credibility scores to witnesses based on their net worth and social media following. The oath swearing itself followed ritual formulas. You're not just saying, "Yeah, I believe him." You're reciting specific words in a specific manner, often while touching a sacred object. Pre-Christian Vikings swore on arm rings dedicated to Thor or other gods. Later, Christians swore on relics or Bibles. The physical act of touching sacred objects while invoking divine witness added weight to the proceedings. You were essentially calling down supernatural punishment on yourself if you lied, which theoretically deterred false swearing. Historians still argue whether people truly believed the gods would strike them down for oath-breaking, or whether it was more like crossing your fingers behind your back, technically sacred but practically negotiable. What's fascinating is how this system created powerful incentives for maintaining good relationships. You're a Viking trying to navigate life, and you constantly need to consider who will swear for me if I get into legal trouble. This meant you couldn't afford to alienate your community. That neighbor you cheated in a land deal 5 years ago? He's definitely not swearing for you when you're accused of theft. The kinsman you insulted at a feast? He'll conveniently remember a prior commitment when you come asking for oath help. The system transformed every social interaction into a potential future legal asset or liability. Family members were the obvious first choice for oath helpers. You're gathering your brothers, cousins, uncles, people who had both blood obligation and family honor at stake in your case. Letting a kinsman hang legally was shameful and could damage the whole family's reputation. But families weren't unlimited resources, especially if you came from a small or low-status lineage. This gave powerful, well-connected families enormous advantages in legal proceedings. A chieftain with dozens of relatives and sworn followers could weather accusations that would destroy an isolated farmer. Social capital literally determined your access to justice. The system also created opportunities for strategic alliance building. You're a farmer who knows you'll never have enough high-status relatives to compete in serious legal battles, so you cultivate relationships with powerful neighbors. Maybe you support them in their disputes, hoping they'll remember the favor when you need help. Maybe you marry your daughter to their son, creating kinship ties that obligate them to provide oath help. Medieval Iceland's political landscape was largely shaped by these overlapping networks of mutual obligation, less like a modern state, and more like interlocking mafias where everyone owed everyone else favors. Oath helpers didn't need to have witnessed the events in question. You're swearing not, "I saw him do it," but rather, "I believe his oath is true," based on his character. This might sound like a recipe for rampant false testimony, but remember, your oath help was an investment of your own social capital. You were betting your reputation that your friend wasn't a liar. Smart people were selective about which oaths they swore and for whom. Some individuals apparently gained reputations as reliable oath swearers whose participation added credibility to any case, while others were known as oath whores who'd swear for anyone who paid them, which made their testimony nearly worthless. The accuser also needed oath helpers, which created interesting symmetries. You're both bringing your respective social networks to battle in proxy form, seeing whose collection of supporters was more convincing. If the accused produced overwhelming oath help while the accuser scraped together barely enough witnesses, the Thing assembly might conclude that the accusation itself was questionable. This could backfire spectacularly on false accusers. You brought baseless charges, failed to support them adequately, and now faced social consequences for wasting everyone's time and trying to harm someone's reputation. Women participated in oath helping, though sources disagree about whether their oaths carried equal weight to men's. Some legal codes suggest a woman's oath was worth half a man's, requiring 2 women to equal 1 male oath helper. Other sources show women swearing oaths without apparent gender discounting. It likely varied by region, time period, and the specific woman's statusa. Wealthy landowner's widow probably commanded more credibility than a poor farmer's wife, which tells us that class could sometimes trump gender in the Viking honor calculus. The system began breaking down as centralized authorities gained power and introduced innovations like written evidence and professional judges. You're living in 13th century Norway, and suddenly the king's court wants documentary proof rather than just your friend's promises. The transition wasn't smooth. Many people preferred the old oath-helping system because it was predictable and based on relationships they understood. Written contracts and external judges felt impersonal and threatening. But centralized power won, as it usually does, and oath-helping gradually became a historical curiosity rather than the foundation of legal proceedings. You're standing in the Thing assembly and the oath-helpers have failed to produce a clear verdict. Maybe both sides gathered equal numbers of supporters, or maybe the case is so ambiguous that even sworn testimony can't settle it. What happens when human judgment reaches its limits? The Vikings had an answer, and you're not going to like it. They turned to ordeal physical tests so brutal that only divine intervention could supposedly save an innocent person. Welcome to trial by boiling water, hot iron, and the kind of logic that makes you grateful for modern jury duty, even if it is boring. The underlying theology was straightforward enough. If you're truly innocent, God or the gods in pre-Christian times will protect you from harm during the ordeal. If you're guilty, the divine powers will allow nature to take its course, meaning you'll suffer exactly the burns, wounds, or drowning that physics and biology predict. It's a system that confused correlation with causation in spectacular fashion, but it persisted across cultures precisely because it offered certainty in impossible situations. You couldn't argue with the results. Your blistered hands or intact skin provided visible, undeniable evidence of guilt or innocence. The most common ordeal involved carrying a red-hot iron bar for a specified distance, usually 9 paces, because Vikings loved their symbolic numbers. You're the accused, and you're watching a blacksmith heat an iron rod until it glows like a miniature sun. When it reaches the proper temperature determined by Well, by someone's best guess, you have to grasp it with your bare hands and walk those 9 paces without dropping it. Your hands immediately begin cooking. The smell of burning flesh fills the air. We're talking sensory horror here that probably made spectators queasy even if they'd seen it multiple times. After completing the walk, your hands are bandaged and sealed with wax or cloth, and you wait 3 days. Here's where the divine judgment supposedly manifests after 3 days. The bandages are removed and the burns are examined. If your wounds are healing cleanly without signs of infection, you're innocent. God protected you by allowing miraculous healing. If the burns are festering, infected, or looking generally nasty, which, let's be honest, is what burns do when you grab red-hot metal, then you're guilty, and the divine powers allowed infection to mark your sin. Historians still argue whether anyone actually believed this or whether it was elaborate theatre with predetermined outcomes, but the sagas record it as serious business, suggesting at least some Vikings took it at face value. Water ordeals offered variations on the theme. You're accused of a crime and tied up before being thrown into deep water, a lake, fjord, or even a large barrel if you're doing budget ordeals. If you float, you're guilty because the pure water rejects your sinful body. If you sink, you're innocent because the water accepts you. The flaw in this system is obvious. Innocent people drowned, which seems counterproductive for a justice system. Some versions had observers ready to pull out sinkers before they actually died, turning it into more of a temporary drowning ordeal, but compliance wasn't universal. You might be declared innocent posthumously, which is great for your reputation but less helpful for your continued existence. The boiling water variant was particularly nasty. You're required to plunge your hand or arm into a cauldron of boiling water to retrieve a stone or ring from the bottom. The depth varied based on the crime's severity. A minor offence might require you to go wrist deep, while serious accusations meant submerging your entire arm up to the elbow. Same 3-day waiting period, same examination of healing patterns. The logic was identical to the hot iron ordeal, just with a different pain delivery mechanism. Some sources mention that the water temperature was verified by boiling eggs in it first, which is both practical and deeply weird. Nothing says divine justice, like egg cooking calibration. What's rarely discussed is how social status affected ordeal administration. You're a wealthy chieftain accused of a crime, and there's suggestive evidence that the iron you carried might not have been quite as hot, or that your examination after 3 days might have been more generous in interpretation. Powerful people had powerful friends administering the ordeals, and funny how they seemed to pass these divine tests more often than poor farmers. The system claimed to bypass human bias through divine intervention, but humans still controlled the heating, the timing, the bandaging, and the final examination. Plenty of room for thumb-on-the-scale behavior. Pre-Christian ordeals invoked Norse gods rather than the Christian god, but the mechanics were similar. You're swearing by Thor's strength or Odin's wisdom that the ordeal will reveal truth, and the physical tests proceeded identically. When Christianity arrived, church authorities were deeply conflicted about ordeals. Theologically, it looked like testing God, which biblical passages explicitly forbade. Thou shalt not put the Lord thy God to the test. But ordeals were so embedded in Germanic legal culture that banning them outright was impractical. The Church eventually developed elaborate blessing rituals to sanctify the proceedings, essentially trying to make them more Christian-y while acknowledging they couldn't eliminate the practice. The ordeal of the cross offered a less physically damaging alternative, though arguably more tedious. You're standing with your arms outstretched in crucifixion pose, and your accuser does the same. Whichever person lowers their arms first loses the case. It tested endurance rather than burn resistance, which sounds almost pleasant until you try holding your arms straight out for, say, an hour. The shoulder pain becomes excruciating. Some contests reportedly lasted hours, with both participants trembling and crying from muscle fatigue. At least you kept your skin, no? Combat trials, remember Holgang, were essentially ordeals with more agency. You're still trusting divine powers to favor the righteous, but you get to swing a sword rather than passively endure torture. This made combat more popular among warriors who figured they'd rather bet on their fighting skills plus divine favor than purely on whether their third-degree burns would miraculously heal. Same superstitious logic, more opportunity for personal competence to affect the outcome. The ordeal system declined in the 13th century when the Fourth Lateran Council formally prohibited clergy from participating in ordeals. Without priests to bless the proceedings and interpret the results, ordeals lost their sacred legitimacy and became just torture with extra steps. You're a 13th century Viking? Well, by then you're really a Scandinavian Christian living in what used to be Viking territory, and suddenly the old certainties are evaporating. Legal systems had to develop alternative evidence, methods witness testimony, documentary proof, professional judge, which eventually led to something resembling modern trials. The transition was messy and took generations, but Western law eventually decided that maybe burning people to determine guilt wasn't the most reliable methodology. You're at a feast. Everyone's had too much mead, and someone across the hall shouts that you're unmanly or accuses you of taking the woman's role in, well, let's just say intimate activities. In modern society, you'd probably roll your eyes, maybe throw an insult back, possibly start a bar fight if you're particularly drunk and stupid. In Viking society, you've just been handed legal grounds for murder. Welcome to the insult economy, where words carried such weight that the wrong accusation could literally get someone killed, and the law would shrug and say, fair enough. The Norse concept of knive encompassed insult, mockery, and disgrace, particularly accusations that impugned someone's masculinity or sexual honor. You're dealing with a culture that valued martial prowess, heterosexual virility, and dominance so intensely that questioning any of these attributes was legal fighting words. Call a man aga, roughly translating to effeminate, unmanly, or sexually passive, and you'd better be ready to back it up with your life. The insult was so serious that some law codes explicitly permitted the insulted party to kill the accuser on the spot without legal consequences. Not assault them, not demand were guild straight up kill them, and the law said that was a proportionate response to having your manhood questioned. The specificity of actionable insults was remarkable. You're not just talking about vague rudeness. Viking legal codes listed particular phrases and accusations that crossed into legally recognized territory, accusing someone of being raga, another variant of unmanly, calling them a coward, suggesting they'd been penetrated sexually by another man, comparing them to a mare female horse with all the sexual implications that carried, or claiming they gave birth. All of these were formal legal offences. The victim could demand compensation, challenge the accuser to holmgang, or in extreme cases, exact, immediate, violent revenge. Some sources suggest that merely calling someone Siv Ma'atha, a man who practices women's magic, was grounds for legal action because magic was associated with feminine power and therefore shameful for men. What's fascinating is how this intersected with Viking concepts of gender and sexuality. You're living in a society with rigid gender roles where being the active partner in same-sex activity wasn't particularly shameful. Vikings were oddly practical about such things, but being passive was considered the ultimate degradation. It wasn't homosexuality itself that triggered legal consequences, it was the implication of feminine submission. This created a bizarre double standard where you could potentially brag about certain same-sex conquests without shame, but being accused of receptive participation could legally justify violence against your accuser. Modern scholars still argue whether this reflects genuine Viking attitudes or whether later Christian scribes exaggerated these elements when recording the sagas. The insult economy extended beyond sexual honor. You're accused of cowardice, of fleeing from battle, refusing a duel, or failing to avenge a family member, and the accusation could destroy your social standing as effectively as any legal sentence. Cowardice accusations were treated seriously in legal proceedings because they struck at the core of warrior identity. If you were known as a coward, people wouldn't swear oaths for you, wouldn't trade with you on credit, wouldn't marry their daughters to you. The accusation itself became a form of social outlawry, even without formal legal proceedings. Some men reportedly committed suicide rather than live with reputations as cowards, which tells you how seriously these insults cut. Interestingly, women could also bring legal cases for insults, though the types of actionable insults differed. You're a Viking woman accused of being a whore, witch, or adulteress, and while these insults didn't carry quite the same immediate violence-justifying weight as male insults, they could still result in legal cases and compensation demands. Some sources show women successfully suing for slander when their sexual reputation was damaged, with the understanding that such damage affected their marriage prospects and family honor. The compensation amounts were substantial, suggesting that female honor, while defined differently than male honor, still had recognized legal value. The law distinguished between public and private insults. You're insulted in a one-on-one conversation versus being insulted in front of witnesses at a thing assembly or feast. The latter was worse because it was witnessed public shaming. Some legal codes specified that insults delivered before 5 people or more crossed into actionable territory, while private insults might be handled informally. This made strategic sense. Private insults damaged your relationship with one person, but public insults damaged your reputation across the entire community. The law recognized that the harm wasn't just emotional, but tangibly economic and social. Poetic insults, night viseur, occupied a special category of offense. You're a skilled poet who composes verses mocking someone's cowardice, sexual inadequacy, or questionable ancestry, and you recite it publicly or carve it in runes for everyone to see. This was considered worse than simple name-calling because poetry was memorable, repeatable, and spread your shame far beyond the initial audience. Some sagas record cases where nithvisur led to blood feuds that lasted generations. The Vikings understood something about viral content long before social media. The most damaging insults weren't one-time events, but self-perpetuating messages that kept circulating and compounding the shame. Physical symbols of insult also carried legal weight. You're finding a carved wooden poley, nightstand planted outside your property with horse genitals mounted on top and runes cursing you and your family. This wasn't just vandalism, it was formal, magical, and social attack. The law in some regions permitted destroying nightstands and seeking compensation for their erection. These curse poles combined insult, magic, and property violation into one spectacular package of offense. They were meant to drive away the landvartir land spirits that protected your property and announce to everyone that you were under supernatural attack, which damaged both your spiritual standing and your agricultural prospects. The church eventually tried to curb the most extreme responses to insults. You're a Christian missionary explaining that Jesus said to turn the other cheek, and Viking converts are staring at you like you've grown a second head. You're telling me that if someone calls me arg, I should just accept it? The cognitive dissonance was profound. Christianity gradually shifted Norse culture away from immediate violent responses to insults, but it took centuries and never fully eliminated the underlying honor-shame dynamics. Medieval Scandinavian law codes show this transition, with insults remaining illegal but the permitted responses becoming less violent fines instead of duels, public apologies instead of bloodshed. What's darkly amusing is how the insult economy created perverse incentives for conflict escalation. You're angry at someone but don't have solid grounds for a legal case against them. Solution: publicly insult them in the most offensive way possible. Wait for them to respond with violence, then you've got them on assault charges. Or alternatively, insult them, and when they don't respond violently, congratulations. You've just proven they're cowards, which further damages their reputation. It was a now-in scenario that clever operators could exploit. The sagas are full of manipulative characters who used the insult system to engineer conflicts that served their interests. The insult economy reveals how deeply personal honor was embedded in Viking legal systems. You couldn't separate legal standing from social reputation, couldn't divorce what people said about you from what you could demand in court. Modern legal systems try to create this separation. Your character and your rights exist independently, but Vikings saw them as inseparable. Your reputation was your legal credit score, and insults were attacks on that credit that justified formal legal action. It's remarkably honest in a way, acknowledging that law operates within social contexts rather than pretending judges and juries are purely objective arbiters of truth. You're probably thinking that Viking society sounds relentlessly masculineal, that emphasis on warrior prowess, sexual dominance, and beard-related decision-making. But here's where things get interesting. Viking women had legal rights that would make their medieval European counterparts weep with envy. While French and English noblewomen were essentially property changing hands from father to husband with minimal say in the matter, Norse women could own land, initiate divorce, and weaponize property law in ways that occasionally made their husbands very, very nervous. The system wasn't exactly feminist by modern standards, let's not get carried away, but compared to the legal non-entities women became in Christian Europe, Viking ladies had some serious leverage. Property rights formed the foundation of women's legal power. You're a Viking woman, and when you marry, you don't lose everything to your husband. Instead, Norse law recognized your separate property interests. You brought a dowry into the marriage, sure, but you also retained ownership of specific items, your clothes, jewelry, household goods, and in some cases, land. If the marriage dissolved, you got your property back, which gave you genuine economic independence in a way that many medieval European women couldn't dream of. Some wealthy women controlled substantial estates, made business decisions without male approval, and generally operated as autonomous economic actors. The marriage contract itself, there were contracts. Vikings loved their legalistic details, spelled out what belonged to whom. You're negotiating your marriage agreement, and the terms specify that you keep ownership of 3 cows, 2 looms, your grandmother's silver, and that farm plot your uncle left you. Your husband Toad gets to manage some of it maybe, but ownership remains yours. This created interesting dynamics when marriages went sour, because suddenly you're threatening to walk away with half the household's productive capacity, and your husband needs to seriously reconsider whether his affair with the neighbor's daughter was worth losing those cows. Divorce was remarkably accessible for Viking women compared to Christian societies. You're unhappy in your marriage for basically any reason. He's impotent, he's a poor provider, he beats you excessively. Some violence was apparently acceptable, but there were limits. He insists on wearing suspiciously feminine clothing, he won't avenge insults to your family, and you could initiate divorce proceedings. The process required witnesses, usually involved announcing your intentions publicly at your front door and again at the local thing. And then, that was it. No papal dispensation needed, no theological gymnastics about whether the marriage was valid in God's eyes. You declared yourself divorced, took your property, and walked away. The grounds for divorce that law codes explicitly recognized are fascinating. You're divorcing your husband because he wore a shirt cut so low that it exposed his chest, which was considered shamefully feminine clothing. This was apparently a legitimate legal complaint in some Norse regions. Or you're divorcing him for wearing tight breeches that showed too much of his form again, too feminine, grounds for divorce. The Vikings had strong opinions about men's fashion choices, and women could legally enforce those opinions by ending marriages. It's like if modern divorce law included a clause about your spouse wearing Crocs. One quirky detail that historians love: women reportedly sometimes staged dramatic divorceries by publicly displaying the divorce declaration at the front door while dressed in men's clothing and then walking away. You're making a statement about gender role violations while simultaneously committing one yourself, which is either deeply ironic or brilliantly strategic commentary. The cross-dressing element supposedly ensured plenty of witnesses noticed what was happening. Nothing like violating gender norms to guarantee everyone remembers your legal declaration. Though sources on this are limited, and it might be saga writers spicing up their narratives rather than common practice. Widows gained even more legal power. You're a widow, and suddenly you're the head of household with full legal rights to manage property, conduct business, arrange your children's marriages, and generally operate as a male equivalent in legal proceedings. Some widows became formidable political and economic players, controlling family resources and wielding influence at things. The downside? You also inherited your late husband's feuds and obligations, which could mean finding yourself in the middle of blood conflicts you didn't start. The sagas mention widows who goaded their sons and male relatives into vengeance, essentially weaponizing masculine honor culture to advance their own interests. Women could testify in legal proceedings, though the weight of their testimony varied. You're a female witness to a crime, and some legal codes counted your oath as equal to a man's, while others discounted it, sometimes requiring 2 or 3 women's oaths to equal one man's. High-status women, particularly landowners or wives of chieftains, typically received more credibility than poor women. Class, as always, complicated gender dynamics. A wealthy woman's testimony might outweigh a poor man's, which tells us the Vikings were flexible about hierarchies when money and status were involved. But legal protection against sexual assault was real, but operated on that familiar compensation-based model. You're raped, and the law recognized this as a serious offense requiring substantial wergild payment to you and your family. The amount varied by your social status. Attacks on highborn women commanded premium compensation. However, enforcement depended entirely on whether your male relatives were willing and able to pursue the case. You couldn't bring legal action independently in most cases. You needed a male representative father, brother, husband, or male guardian. This limited your practical access to justice, even when the law theoretically protected you. Women occasionally manipulated legal loopholes to achieve outcomes the system didn't explicitly intend. You're finding sagas describing women who technically followed divorce procedures, but did so in ways that maximized damage to their ex-husband's, timing the announcement to coincide with harvest season, so he loses critical labor, or publicly declaring grounds that humiliated him socially, even if they weren't the real reason for the split. Some women apparently became skilled at weaponizing the legal system's patriarchal assumptions, using the fact that men underestimated them to maneuver more effectively. Historians still argue whether Viking women's legal rights resulted from genuine gender equality or from practical necessity in a society where men were frequently absent on raids and trading voyages. If you're gone 6 months raiding England, you need to leave someone competent in charge of the farm, and turns out women were perfectly capable of managing property and making decisions. Whether this reflected ideological beliefs about gender equality or just pragmatic resource management remains debated. Probably it was both, varying by individual families and regional customs. Christianity's arrival gradually eroded many of these legal rights. You're watching the church import continental European ideas about women as legal minors who needed male guardianship, about marriage as indissoluble sacrament rather than dissolvable contract, about women's testimony being inherently suspect. The transition took generations, but by the late medieval period, Scandinavian women's legal position had declined significantly from Viking Age standards. It's one of history's ironies that Christianization, often framed as civilizing influence, actually reduced women's legal autonomy in Norse societies. You're standing at a thing assembly watching someone receive their first formal warning for a property dispute, and you realize the Vikings understood something modern legal systems sometimes forget: not every offense deserves the nuclear option. The Norse legal framework included a fascinating 3-tiered warning system that gave troublemakers multiple chances to correct their behavior before society brought down the hammer. Think of it as graduated consequence. Elementary school teachers would recognize the model, except instead of losing recess privileges, the final stage involves becoming a hunted outlaw with zero legal protections. Motivation to comply was strong. The first warning was essentially a public heads-up that you were on thin ice. You're the person causing problems. Maybe you've been letting your livestock repeatedly wander onto neighbours' fields, or you've failed to pay a debt on time, or you've been starting fights at gatherings but haven't seriously injured anyone yet. The Thing Assembly or local community leaders would issue a formal summons requiring you to appear and answer for your behaviour. This wasn't a trial, yet it was an intervention. You'd stand before the assembled community while someone recited your offences, and you'd be formally told to knock it off. No penalties attached to this first warning beyond public embarrassment, but everyone now knew you were a problem case. The genius of this system lay in its transparency. You're being warned in front of witnesses, which meant you couldn't later claim ignorance about community expectations. The public nature also meant your neighbours were now watching you specifically, waiting to see if you'd reform or continue down the troublemaker path. It created social pressure beyond the legal warning. People started avoiding business with you, stopped inviting you to feasts, generally treated you as someone on probation. For most Vikings whose social standing was everything, this first warning was mortifying enough to prompt behaviour changes. If you ignored the first warning, the second level involved actual consequences, but still stopped short of permanent damage. You're now facing fines, confiscation of specific property items, or temporary restrictions on your legal rights. Maybe you're forbidden from trading at certain markets for 6 months, or you're required to pay compensation to the people you've wronged, or you're barred from speaking at the next Thing Assembly. These penalties hurt economically and socially, but they were survivable. You could comply, pay up, behave yourself for a period, and eventually return to full community standing. The door remained open for rehabilitation. The second warning also typically involved more formal legal proceedings. You're not just getting a verbal scolding anymore, there's an actual case with evidence presented, witnesses testifying, and a judgment rendered. The Thing Assembly would hear arguments about whether you'd genuinely violated the first warning or whether circumstances had changed. Some people apparently tried arguing technicalities. You told me to keep my pigs off his barley field, that this was his wheat field, totally different, which probably worked about as well as you'd expect. Viking legal assemblies weren't known for appreciating clever loopholes when the spirit of the law was obviously being violated. The third warning was the point of no return. You're looking at serious consequences, heavy financial penalties that might bankrupt you, loss of property rights, potentially even lesser outlawry if the offence was severe enough. This was the legal system telling you that you'd exhausted community patience and your next violation would result in complete social exclusion. Some regions apparently included literal last chance declarations where you were publicly informed that one more incident, just one, would trigger full outlawry proceedings. Living under that kind of suspended threat must have been psychologically exhausting, like waiting for a sword to drop. What's interesting is how this graduated system prevented hasty outlawry declarations. You're the victim of someone's repeated offences, and you're absolutely furious, demanding they be outlawed immediately. But the legal system forced a cooling-off period, multiple chances for resolution, and escalating responses that matched offence severity. This protected society from impulsive decisions made in anger. Outlawry was such a serious sentence, remember, it essentially created a walking corpse that using it as a first response to minor offences would have depopulated communities. The 3-warning system ensured outlawry was reserved for truly incorrigible individuals. The system also accommodated genuine mistakes versus willful defiance. You're someone who accidentally violated a property boundary once? First warning, maybe you didn't know where the line was. Here's clarification, don't do it again. You apologize, make minor restitution. Everyone moves on. You're someone who keeps deliberately violating boundaries after being warned twice. Now you're demonstrating contempt for the community, and the third warning reflects that escalation. The law distinguished between ignorance, accident, and malicious intent, adjusting responses accordingly. Historians still argue whether this reflects sophisticated legal philosophy or just pragmatic recognition that people make mistakes. Interestingly, the warning system applied to collective violations too. You're part of a group that's been causing trouble, maybe a bunch of young men who keep disrupting thing assemblies with drunken brawling, or a family that refuses to settle their feuds peacefully. The warnings could target the entire group, creating peer pressure among members to control each other's behavior. If your cousin's stupidity was risking the whole family's legal standing, you had strong incentive to sit him down for a serious talk. This transformed law enforcement into a distributed responsibility rather than purely top-down authority. The timeline between warnings varied by region and offence severity. You're waiting anywhere from a few months to several years between escalations, depending on local custom. Serious offences accelerated the process. Violence at a thing assembly might jump straight to second or third warning level. Minor offences allowed years between warnings, giving people genuine time to demonstrate reform. The flexibility prevented rigid application that might punish someone severely for circumstances beyond their control while still maintaining consequences for persistent troublemakers. Children and young adults apparently received more lenient treatment under this system. You're a teenage Viking who keeps getting into stupid fights, and the community recognizes you're young and dumb rather than genuinely dangerous. The warnings might be more numerous or the consequences lighter, acknowledging that people mature and judgment improves with age. This wasn't formalized as separate juvenile justice. Vikings didn't think that. Waybit sagas and legal texts suggest communities informally adjusted expectations based on age and experience. Old enough to raid, old enough to face full adult consequences. Still learning basic social skills? Maybe we give you extra chances. Women could be warned under this system too, though the offences that triggered warnings differed from men's. You're a woman repeatedly accused of spreading malicious gossip, or practicing magic that disturbed the community, or refusing to control your slaves properly. The same graduated warning structure applied, though the final consequences might be different. Women were rarely outlawed in the full sense. Instead, they might face forced marriage dissolution, property confiscation, or exile to family members in other regions. The system bent gender norms around practical realities while maintaining the basic three-tier structure. The warning system's effectiveness depended entirely on community cohesion and shared values. You're living in a tight-knit settlement where everyone knew everyone, where reputation mattered intensely, and where social exclusion was genuinely terrifying. The warnings worked because the threat of ultimate exclusion outlawry loomed behind them. As Norse societies became more urbanized and anonymous, as people could simply move to new towns where their warnings weren't known, the system's power diminished. By the late medieval period, centralized royal justice had mostly replaced community-based graduated warnings with standardized legal penalties. You're navigating the Viking legal system feeling pretty confident about warnings, oaths, and compensation structures. And then you encounter the legal status of thrall slaves, and suddenly everything gets murky. Here's where Norse law revealed its most troubling contradictions. Thralls were simultaneously property like livestock and people with at least some human rights, existing in a legal twilight zone that created bizarre edge cases and moral gymnastics. The Vikings, for all their sophisticated approaches to free people's conflicts, never quite figured out how to consistently handle human beings they'd decided to own. The resulting legal framework was a mess of contradictions that even law speakers probably struggled to navigate without headaches. At the most basic level, you're a thrall and your property. Your owner could buy you, sell you, trade you for 3 cows and a barrel of salted fish, give you as a gift, or include you in their will like any other asset. You had roughly the same legal standing as a horse, valuable, useful, requiring maintenance, but fundamentally a thing rather than a person. If someone killed you, they owed your owner compensation for destroyed property, not weregild for murdered humanity. The payment reflected your market value as a worker, not your worth as a human being. A skilled craftsman thrall might be worth 15 ounces of silver, while an unskilled labourer thrall might fetch 5. Your life had a price tag, and it wasn't based on your personhood. But here's where it gets complicated. Thralls could sometimes testify in legal proceedings, which objects definitely couldn't do. You're a thrall who witnessed a murder, and depending on the region and circumstances, your testimony might be admissible, though it carried less weight than a free person's oath. Some legal codes required torture to verify thrall testimony, operating on the assumption that slaves would lie to protect their masters unless physical pain encouraged honesty. This is both horrifying and logically inconsistent. If thralls were mere property, their testimony should be irrelevant, like asking a sword for its opinion on who wielded it last. The fact that thrall testimony existed at all acknowledged some degree of human agency and moral responsibility. The treatment of crimes committed by thralls created legal headaches. You're a thrall who steals from someone other than your master and who's legally responsible. Some regions held the master accountable, requiring them to pay compensation as they would if their dog bit someone. The owner bears responsibility for controlling their property. Other regions recognized the thrall's agency in committing the crime and permitted punishment of the thrall directly, usually through beating, mutilation, or even execution for serious offences. This dual system, sometimes treating thralls as responsible agents, sometimes as mere extensions of their masters, will reveal deep confusion about where thralls fit in the moral and legal universe. Sexual relationships between free people and thralls generated spectacular legal complications. You're a free man who impregnates a thrall woman, and depending on regional law, that child might be born free, born enslaved, or born into some intermediate status requiring eventual manumission. Some codes held that children inherited their mother's status, making thrall women's children automatically enslaved, regardless of the father's status. Other codes recognized paternal claims and allowed free fathers to claim their thrall-born children as legitimate offspring. This created perverse incentives. Free men could father children on thrall women without the legal and financial obligations they'd face with free women, essentially exploiting the ambiguous legal status. Female thralls faced particular vulnerability to sexual assault from their masters and other free men. You're a thrall woman being raped by a free man who isn't your master, and the legal system treated this as property damage to your owner rather than assault against you personally. The compensation went to your master for diminished value of his property, not to you for violation of your bodily autonomy. Some laws specified that rape of a thrall by her own master wasn't even illegal. He owned her, therefore he could do what he wanted with his property. Historians still argue whether this accurately reflected Viking attitudes or whether Christian scribes recording the laws centuries later emphasized the most brutal elements to justify their own conversion narrative. Manumission. Formal freeing of thralls followed specific legal procedures. You're a master choosing to free a thrall, and you typically needed to do so publicly with witnesses, often at a thing assembly. Some regions required you to formally buy the thrall's freedom through ritual payment. Even though you already owned them, apparently you were purchasing their freedom from the collective legal status of slavery, not from yourself specifically. Freed thralls became freedmen, laisingi, gaining legal personhood but not full equality with those born free. They still owed obligations to their former masters, sometimes for life, creating a permanent client relationship that looked suspiciously like slavery with extra steps. The legal obligations freedmen owed their former masters were substantial. You're newly freed, congratulations, but you still need to provide labor during harvest season. You can't leave the region without permission. You owe a portion of your income to your former master, and if you die without heirs, your property reverts to them. Only your children or grandchildren, sources vary, would gain full free status without these obligations. This meant true freedom was often a multi-generational project, which kept formerly enslaved people in dependent relationships long after formal manumission. Some cynical historians suggest masters freed thralls precisely to create this permanent labour obligation without the maintenance costs of ownership. Thralls could apparently own property in some limited contexts, which is philosophically bizarre. You're property yourself, but you can own property? The logic seems to be that masters allowed thralls to accumulate goods as incentive for good behaviour, with the understanding that everything ultimately belonged to the master, but the thrall had user rights. Some thralls reportedly bought their own freedom this way, saving enough to pay their market value. This required masters who honoured such agreements, which apparently happened often enough that it became a recognised path to freedom, though cynics might note that masters could simply confiscate the accumulated wealth and refuse freedom whenever they wanted. The treatment of runaway thralls revealed the system's underlying violence. You're a thrall fleeing your master, and if caught, you faced brutal punishment, beating, branding, mutilation of ears or nose to mark you permanently as a runaway, or execution if you'd run away multiple times. But here's the twist. If you made it to a church in Christianara, Scandinavia, you might claim sanctuary, creating tension between secular slave law and Christian doctrine about all souls being equal before God. The church never quite convinced Vikings to abolish slavery, but they slowly made it more difficult to maintain, creating legal friction that contributed to slavery's eventual decline in Scandinavia. The Viking slave trade operated on massive scale, with thralls captured from raids across Europe being bought and sold in established markets. You're at a slave auction in Dublin or Hedeby, watching human beings assessed like livestock, teeth checked, muscles examined, skills evaluated. The legal framework supporting this commerce was extensive: bills of sale, ownership documentation, regulations about transporting slaves across territories, rules about slave ships and cargo. The bureaucracy of human trafficking was as developed as any other commercial enterprise, which tells us slavery was too economically important for Vikings to treat casually, even as their legal codes struggled with the inherent contradictions of owning people. You're walking through your carefully tended barley field and discover your neighbour's pigs have gotten loose again, trampling your crops and rooting through everything like tiny armoured tanks of destruction. Your first instinct is probably to grab the nearest weapon and solve this problem permanently, but Viking law had surprisingly detailed regulations about exactly this scenario. Welcome to the world of livestock law, where wandering pigs, aggressive bulls, and property-destroying goats generated enough legal disputes to fill volumes of precedent. The Vikings understood that in agricultural societies, animals weren't just property. They were four-legged chaos agents requiring extensive legal frameworks to prevent their antics from triggering blood feuds. The foundational principle was simple. You're responsible for controlling your animals. Your cow wanders onto someone else's land and eats their grain? That's your fault, and you owe compensation based on the damage done. The law didn't care if your fencing was expensive or if the cow was particularly clever at escaping ownership meant responsibility. Some legal codes specified that you needed to maintain adequate fencing around your property, with adequate defined by local custom. Fences that couldn't contain sheep were inadequate for cattle. Fences that worked in summer might be insufficient for winter, when hungry animals got more aggressive about finding food. You were expected to adjust your containment strategies seasonally. The compensation calculations for crop damage were remarkably specific. You're assessing how much barley got destroyed, factoring in the growth stage. Trampled seedlings cost less than trampled mature grain ready for harvest, the size of the damaged area, and the number of animals involved. Multiple legal texts preserve formulas for these calculations, suggesting Vikings took agricultural damage very seriously. A single pig rooting through a small garden patch might cost you a few ounces of silver. A herd of cattle demolishing half an acre of ripe wheat could bankrupt you. The system incentivized careful animal management because the financial consequences of livestock liberation could be devastating. Repeat offenders faced escalating consequences under that familiar three-warning framework. Your animals escape once, pay damages, fix your fences, everyone moves on. Your livestock become serial trespassers, The second time involves higher fines plus potential confiscation of the offending animals. Third offence, you might lose the animals permanently, face restrictions on keeping certain types of livestock, or in extreme cases, pay penalties that approached Wergild territory. Some communities apparently appointed animal wardens whose job was tracking repeat offender livestock and their negligent owners, basically agricultural probation officers for cows. Aggressive animals created special legal categories. You're the owner of a bull with a reputation for charging people, or a dog that's bitten multiple neighbours, and suddenly you're facing strict liability for any harm they cause. Some legal codes explicitly stated that once an animal was known to be dangerous, the owner bore full responsibility for all subsequent incidents, with compensation increased beyond standard rates. You couldn't claim, "Oh, he's never done this before," after your bull gored someone, when half the village knew that bull was a menace. This proto-strict liability recognized that some animals were inherently risky and required owner accountability. Here's where things get weird. Animals could theoretically be tried for crimes, though Viking practice was less formal than the famous medieval animal trials of Christian Europe. You're dealing with an ox that killed someone by kicking or trampling them, and some sources suggest the animal itself could be declared forfeit, essentially executed or confiscated as punishment. Historians still argue whether this reflected genuine belief that animals bore moral responsibility or whether it was just practical removal of dangerous creatures wrapped in legal language. The distinction between "this ox is guilty" and "this ox is too dangerous to keep" probably didn't matter much to the ox. Ownership disputes over animals generated constant litigation. You're claiming that a cow in your neighbour's herd is actually yours, stolen or strayed months ago, and now you need to prove it. Vikings used brands, ear notches, and other identifying marks, but these could be altered or were sometimes ambiguous. Witness testimony about which cow gave birth to which calf, who was seen with which animals, when, and who had owned animals of that description became crucial. Some communities maintained informal registries of livestock markings, essentially early databases for identifying property. Your unique ear-notch pattern was on file at the local thing, so later disputes could reference the official record. The law distinguished between finding stray animals and stealing them, but the line could blur. You're finding a wandering sheep with no visible owner, and you're required to announce the find publicly, usually at the next thing assembly, or by proclaiming it loudly in the settlement. If the owner came forward within a specified period, often a year and a day, Vikings loved that time frame. You returned the animal and might receive a small finder's fee. If nobody claimed it, the animal became yours. But if you found a stray and just kept it without announcement, that was theft, subject to the same penalties as any other stealing. The system encouraged returning lost animals by rewarding honesty while punishing sneaky appropriation. Damage caused by wild animals fell into different legal territory. You're losing sheep to wolves or bears, and that's just bad luck. Nobody owed you compensation unless you could prove someone deliberately drove the predators toward your flock, which seems like a difficult case to prove without video evidence. Some communities organized collective hunts to eliminate dangerous predators, recognizing that individual farmers couldn't handle the problem alone. Participation in these hunts was sometimes legally required if you wanted to keep livestock in certain areas, creating communal responsibility for managing the wildlife threats everyone faced. Animals, as payment in Wergild or fines, created interesting valuation challenges. You're paying compensation in livestock rather than silver, and the law needed standards for what counted as acceptable payment. A cow wasn't just a cowage. Health, milk production, breeding status all affected value. Old cows past breeding age were worth less than young heifers ready to calve. Bulls commanded different prices than steers. Some legal text specified that livestock payments should be of average quality to prevent people dumping their sick or elderly animals as compensation. This required assessment by neutral parties who knew animals, creating yet another specialized legal role, official livestock appraiser. Shared pasture usage generated complex regulatory frameworks. You're grazing your animals on common land that multiple families used, and rules governed how many animals you could graze, during which seasons, and how disputes about overgrazing got resolved. Some communities used a system where your grazing rights corresponded to how much land you owned or how much you contributed to maintaining common fences. Others allocated rights based on tradition and precedent. Violating grazing limits could result in fines, animal confiscation, or loss of future grazing privileges. These commons management systems were surprisingly sophisticated, recognizing that unregulated shared resources led to overuse and degradation. The treatment of animals also revealed something about Viking values and priorities. You're noting that killing someone's working animal and ox or horse crucial for ploughing and transport carried higher compensation than killing their pigs or sheep. The law recognized functional value beyond simple market price. An animal that enabled survival through its labor was worth more than an animal that was just meat on the hoof. Some codes even specified that killing a pregnant animal required additional compensation for the lost offspring, showing attention to future value and reproductive capacity. Vikings weren't sentimental about animals, but they were ruthlessly practical about their economic importance. You're sitting down at a feast thinking you'll just have a relaxing evening with some mead, and you quickly realize that Viking drinking wasn't casual, it was a legally regulated performance where every toast had hierarchy, every refusal carried meaning, and getting drunk was both mandatory and potentially legally dangerous. Welcome to the Alistake's drinking code, where those wooden poles with evergreen branches outside taverns weren't just decoration but legal markers indicating alcohol was available for sale, and where the act of drinking became so wrapped up in honor, obligation and social performance that modern bar etiquette looks delightfully simple by comparison. The Alistakes themselves, those markers that gave this whole system its name-served, crucial legal functions. You're a household brewing ale for sale, and you needed to publicly announce this by erecting a pole decorated with evergreen branches or sometimes a bundle of straw outside your property. This wasn't optional marketing, it was legal requirement in many regions. The stakes informed travelers that alcohol was available and simultaneously put you under specific legal obligations about quality, pricing, and conduct. Operating an informal tavern without the stakes was illegal, essentially bootlegging in a society that took its drinking regulations very seriously. The stakes also helped tax collectors identify who was selling alcohol, because Vikings loved taxing anything that generated revenue. Inside these drinking establishments or at private feasts, the toast hierarchy was rigid and inviolable. You're not just randomly raising your cup whenever you feel like it. There's an order, people. The first toast always went to Odin, Thor, or after Christianization, to Christ and the saints. You honored the gods before honoring anyone mortal, which made theological sense and also prevented anyone from claiming they were more important than divine powers. The second toast typically honored the king or local chieftain, acknowledging earthly authority. Third toast? That was flexible, maybe to Freya for good harvest, maybe to deceased ancestors, maybe to specific living people you wanted to honor. Jumping the order was insulting and could trigger conflicts. The drinking vessels themselves carried social significance. You're drinking from a shared horn that gets passed around the table, and refusing to drink when it reaches you was a serious insult to whoever offered it. Some sources describe elaborate horn-passing rituals, where specific people had to drink in specific order, with the quality and size of the horn reflecting the drinker's status. Chieftains drank from larger, more decorated horns. Important guests received the next best vessels. Lower status participants made do with simpler cups or shared vessels. The whole performance reinforced social hierarchies with every round of drinks. The obligation to drink, truly drink, not just sip politely created interesting legal situations. You're expected to drain your vessel when toasting, particularly during formal ceremonies. Drinking to the bottom wasn't just enthusiasm, it was showing respect and commitment. Half-hearted sipping suggested you didn't genuinely mean your toast, which could insult the person or deity being honored. Some feast accounts describe men becoming thoroughly drunk, not from desire, but from social obligation. You couldn't refuse toasts without appearing cowardly or disrespectful. Historians still argue whether the famous Viking drinking capacity was genetic, cultural training, or simply survival adaptation to peer pressure backed by potential violence. What you said while drunk had legal consequences, which seems profoundly unfair, but there it is. You're absolutely hammered at a feast, and you make some boastful oath. I swear I'll raid England next spring and bring back a king's ransom. And congratulations, you're now legally bound to attempt it. Oaths sworn while drinking were considered binding, operating on the logic that alcohol revealed true intentions by lowering inhibitions. Some men apparently used this strategically, getting rivals drunk and then maneuvering them into making oaths they'd regret sober. Hey, you seem like you could totally fight that bear tomorrow, want to swear an oath about it? The next morning's hangover came with legal obligations attached. The concept of compulsory conviviality governed tavern behavior. You're drinking in a public establishment, and you were expected to be social, friendly, and participatory in the general atmosphere. Sitting silently in the corner nursing one drink all evening was suspicious behavior that could get you expelled or worse, people wondered what you were hiding or plotting. Some legal texts mention that refusing to toast with others or declining to share news and stories marked you as antisocial, potentially even an outlaw trying to avoid recognition. Drinking establishments were information exchanges as much as businesses, and participation was the entry fee. Violence at drinking establishments faced strict penalties, but with typical Viking nuance about intent and honor. You're in a brawl that started over a perceived insult, and if you started it, you faced heavy fines and potential outlawry, because fighting at someone's feast or in their tavern violated hospitality laws. The host had provided food, and drink attacking guests under their roof was dishonorable. But if someone insulted you first, particularly with those legally recognized Neve insults we discussed earlier, your violent response might be justified or at least result in reduced penalties. The law tried to distinguish between drunken hotheads and legitimate honor defenses, though the line was often unclear. Women's participation in drinking culture varied by context and region. You're a woman at a feast, and you might be expected to serve drinks to men, which positioned you as hostess, but also gave you power over the drinking pace and who received honor through larger or better portions. Some high-status women participated in toasting directly, particularly widows or landowners who commanded respect in their own right. But the sources also show women being excluded from heavy drinking sessions, possibly because the combination of alcohol and masculine honor competition led to violence that made female presence inappropriate. The double standard was obvious. Men who drank heavily were fulfilling social obligations. Women who did the same risked being labeled as having loose morals. The quality requirements for ale sold at taverns were surprisingly strict. You're brewing weak, watered-down ale and trying to sell it at full price? That was fraud, subject to fines and potential closure of your establishment. Some legal codes specified that ale needed to meet minimum strength standards, though how they measured alcohol content without modern tools is unclear, probably taste testing by experienced drinkers who knew what proper ale should be. Selling spoiled or contaminated ale could result in even harsher penalties, particularly if someone got sick. The Vikings understood that communal drinking required trust in the product's safety and quality. The phenomenon of aloud drinking sessions held to honor the deceased had specific legal and social structures. You're attending a funeral feast where drinking was both memorial act and legal proceeding, as inheritance was often formally transferred during these gatherings. The deceased's heir would drink from the inheritance horn, symbolically and legally accepting their new position. These alawakes lasted days sometimes, with enough alcohol consumed that modern livers would surrender preemptively. But it wasn't just partying, it was ritual transition of property and status, witnessed by the community and legitimized through ceremonial drinking. You're standing in a muddy field arguing with your neighbor about where exactly his land ends and yours begins, and you're about to discover that Vikings had incredibly sophisticated methods for determining property boundaries, methods that didn't involve GPS, surveyors with fancy equipment, or legal documents filed in some dusty county office. Instead, you're relying on stone markers, community memory, and the kind of detailed oral testimony that would make modern lawyers weep with frustration. Property disputes were constant in Viking society because land was literally everything. Your food source, your wealth, your legacy, and the law developed elaborate procedures to prevent every boundary disagreement from escalating into a multi-generational blood feud over 3 feet of disputed pasture. The primary boundary markers were stones, deliberately placed and often quite large. You're looking at rocks that couldn't be easily moved or accidentally relocated by someone hoping to expand their property. These weren't just random stones. They were often distinctive in color, shape or size, making them recognizable landmarks. Some communities carved marks into boundary stones, creating permanent identification that couldn't be disputed. The placement happened during formal ceremonies, with witnesses present, specifically so that later generations couldn't claim the boundaries were different. Children were often brought to witness boundary placements because they'd become the oral records 50 years down the road when the original landowners were dead. Natural landmarks supplemented stone markers. You're using that distinctive oak tree, that unusual rock formation, that creek bend as reference points for where property lines ran. The legal texts mention boundaries described as from the bent pine to the red boulder to where the stream forks. Remarkably specific when you're standing there looking at the actual landscape, maddeningly vague if those features later changed. Trees died, streams shifted course, distinctive rocks got moved by floods. This created disputes that required reconstructing what the landscape looked like decades earlier, essentially archaeological detective work performed by people's memories. The practice of beating the bounds or walking the property perimeter happened periodically to maintain community knowledge of boundaries. You're joining a procession of neighbors who literally walk the entire boundary of a property, stopping at each marker to verify its location and condition. These walks weren't casual strolls, they were legal proceedings with witnesses who could later testify about boundary locations. Some communities did this annually, others every few years. The walks served multiple purposes. They maintained the physical markers, refreshed everyone's memory about boundaries, caught any attempts at sneaky marker relocation, and socialized the next generation into knowing the landscape's legal geography. Children's participation in boundary walks was often emphasized through memorable events. You're a Viking child being lightly beaten or dunked in cold water at specific boundary markers, creating traumatic memories that ensured you'd remember those exact locations for life. Sounds harsh, but it was effective. 60 years later, you could testify, yes, I remember that boundary stone because that's where they threw me in the creek when I was 8. Historians still argue whether this was common practice or exaggerated by later writers, but multiple sources mention using physical sensation to imprint boundary knowledge on young minds. Nothing says property law is important, like childhood dunking rituals. Fence disputes were their own special category of boundary conflict. You're responsible for maintaining your side of a shared fence, and if your section falls into disrepair, your neighbor's animals can legally wander onto your property, and you can't demand compensation because you failed in your fence maintenance obligation. Some legal codes specified that shared fences required equal contribution from both neighbors in materials and labor. If you refused to maintain your section, your neighbor could do the work and bill you for it, with the thing assembly enforcing payment. Fences weren't just practical barriers, they were legal agreements made of wood and stone. The fence viewer role existed in some communities. essentially a neutral party who inspected disputed fences and rendered judgments about who was responsible for repairs. You're calling in the fence viewer because you claim your neighbour's section collapsed first and caused a chain reaction that destroyed your section, while he claims the opposite. The fence viewer examines the damage, considers testimony, maybe consults other experts, and issues a binding decision about responsibility. It's arbitration for agricultural infrastructure, which sounds boring but was crucial for preventing minor fence disputes from becoming major property conflicts. When oral testimony about boundaries conflicted, the law had methods for resolution. You're gathering the oldest surviving community members who could remember the original boundary placement. Their collective testimony carried enormous weight, operating on the assumption that multiple independent memories were more reliable than individual claims. If 3 80-year-old men all agreed the boundary ran past the oak tree, that was probably where it was, even if some written description suggested otherwise. The Vikings trusted human memory more than documents, perhaps because they'd seen how easily documents could be altered or forged. Disputed boundaries sometimes triggered formal investigations that resembled archaeological digs. You're excavating around suspected boundary stone locations, looking for evidence of original placement. Maybe there's a distinct layer of soil showing the stone was deliberately set. Maybe there are other stones arranged in patterns that indicate intentional marking. Some legal proceedings involve digging test pits along disputed property lines, searching for buried markers that had been covered by soil accumulation over decades. It's like CSI, Viking property law, except the evidence is rocks and dirt rather than DNA. The concept of adverse possession existed in protoform. You're using a strip of disputed land for 20 years without objection, and some legal codes recognize that long-term use created presumptive ownership rights. If the other party never complained, never challenged your use, never demanded compensation, their silence implied consent to your possession. This prevented people from sitting on property claims for decades, then suddenly demanding restitution east or lose it, essentially. However, proving that you'd used land openly and continuously without objection required witness testimony about agricultural practices, grazing patterns, and other activities spanning years. Property division among heirs created boundary nightmares. You're a landowner with 3 sons, and you need to divide your property fairly but fairly might mean equal quality rather than equal size. One portion might be smaller, but have better soil or water access. Legal proceedings to settle inheritance boundaries could drag on for years, with siblings hiring oath helpers to support their claims about what their father promised or intended. Some families apparently maintained internal feuds over inheritance boundaries that outlasted the original siblings and continued through their children and grandchildren. Nothing says family values like multi-generational property litigation. The law also recognized that boundaries could legitimately shift over time through natural processes. You're losing land to coastal erosion or river meandering, and that was just bad luck. The ocean wasn't legally obligated to respect your property rights. Similarly, if land accumulation occurred through natural processes, the additional land belonged to whoever owned the adjacent property. This created incentives for coastal landowners to build structures that encouraged sediment deposition, essentially terraforming their way to more acreage. Some legal disputes centered on whether land changes were natural or resulted from human manipulation of waterways. You're watching 2 men who aren't related by blood slice their palms open, mix their blood, and swear oaths that bind them more tightly than many biological siblings. And you're realizing that Vikings understood something modern societies sometimes forget. Family isn't just about DNA. The institution of blood brotherhood, fostbrotherlag, created legally recognized kinship through ritual rather than birth, and these artificial family bonds carried genuine legal weight. You could inherit from your blood brother, you were obligated to avenge their death, you swore oaths supporting them in legal proceedings, and betraying them was considered as shameful as betraying a biological sibling. It was legal fiction that became social fact through the sheer force of communal recognition and enforcement. The ritual itself varied by region but typically involved some combination of blood mixing, oath swearing, and passing under raised turf. You're standing with your soon-to-be blood brother while someone cuts 3 strips of sod but leaves them attached at both ends, creating arches of earth you both crawl under. The symbolism was powerfully, or being reborn into a new kinship relationship, passing through the earth together like emerging from the same womb. Then came the blood part, cutting your palms or arms and either letting the blood drip onto the same ground, mixing it in a bowl, or directly pressing the wounds together. Some sources mention drinking mixed blood or smearing it on each other, which sounds equal parts dramatic and unsanitary. Medieval wound infection rates were probably impressive. The oaths sworn during blood brotherhood ceremonies were specific and binding. You're promising to treat your blood brother as a true sibling, to share resources in need, to support them in legal disputes, to avenge their death if they're murdered, to treat their enemies as your enemies and their friends as your friends. Essentially, you're creating an alliance that obligated your entire extended family network, because supporting you meant supporting your blood brother. Some blood brother pairs apparently coordinated their oaths so that one would inherit from the other if either died childless, creating inheritance rights that superseded claims from distant biological relatives. The legal system recognized these arrangements as legitimate. What's fascinating is how blood brotherhood could trump biological kinship in some contexts. You're facing a legal dispute where your biological cousin and your blood brother have conflicting interests, and you're obligated to support your blood brother first. The oath you swore created a relationship that in some ways exceeded natural family bonds, probably because it was voluntary rather than accidental. You chose your blood brother. You didn't choose your annoying cousin. The voluntary nature created expectations of stronger loyalty. Historians still argue whether blood brotherhood was primarily about genuine friendship or strategic alliance building, but honestly, it was probably both, varying by individual relationships. The practice served crucial social functions in a mobile, violent society. You're a Viking trader heading to Constantinople, a raider joining an expedition to Ireland, or a settler moving to Iceland, and you're forming blood brother bonds with people you'll rely on for survival. These weren't casual friendships. They were formalized mutual aid societies where betrayal carried the same social consequences as betraying family. In situations where you couldn't count on biological kin being present, manufactured kinship provided similar support networks. It's like insurance policies, except instead of monthly premiums, you paid with blood and sacred oaths. Women could participate in similar bonding rituals, though the terminology and specific practices differed. You're finding references to oath sisters, or women who swore binding loyalty to each other, though sources on this are frustratingly sparse. What we know suggests women's oath bonds carried similar obligations around mutual support, testimony in legal proceedings, and inheritance rights in some cases. The practice might have been less formalized than male blood brotherhood, or simply less documented because male saga writers didn't find it as narratively interesting. Either way, the existence of female bonding rituals suggests Vikings recognized that manufactured kinship served purposes across gender lines. Blood brotherhood oaths could be broken, but the consequences were severe. You're betraying your blood brother. Maybe you refuse to help him in a legal case. Maybe you actively work against his interests. Maybe you fail to avenge him after he's murdered. And you've just committed one of the most shameful acts in Viking society. The sagas are full of blood brother betrayals presented as ultimate moral failures, the kind of treachery that destroyed a man's honor more thoroughly than almost any other offense. Some stories suggest that oath breakers faced supernatural consequences in addition to social ones. The gods themselves supposedly punished those who violated sacred bonds, though that might be saga writers adding drama. The legal system had to navigate complicated situations when blood brothers came into conflict. You're blood brothers with someone who commits a crime against your biological family, and suddenly you're caught between competing obligations. Do you support your blood brother as your oath requires, or do you support your biological kin? The law didn't have clear answers for these edge cases, which probably meant they were resolved through community pressure, negotiation, or simply whoever had more supporters backing their position. Some blood brother pairs reportedly dissolved their bonds formally when conflicts became irreconcilable, which required its own ritual of renunciation with witnesses. The Christian Church viewed blood brotherhood with suspicion, seeing it as quasi-pagan ritual that competed with spiritual brotherhood in Christ. You're a Christian missionary trying to convince Vikings that all believers are brothers in faith and therefore don't need blood-mixing ceremonies, and you're not having much luck. The practice persisted well into the Christian era, though it gradually became less formalized and lost some of its legal weight as church-based bonds like godparenthood offered alternative frameworks for manufactured kinship. Godparents created similar obligations around supporting a child's upbringing and Christian education, providing the social functions of blood brotherhood in more theologically acceptable packaging. Strategic blood brotherhood could create powerful political alliances. You're a chieftain forging blood brother bonds with other leaders, essentially creating a coalition held together by oaths rather than treaties. These alliances could shift power dynamics across entire regions as blood brothers brought their respective follower networks into mutual support arrangements. Some of medieval Iceland's political landscape was shaped by these interlocking blood brotherhood ties, creating webs of obligation that determined who supported whom in major disputes. It was network politics before social networks, with human bonds serving as the connections. The practice also created interesting legal situations around collective responsibility. You're a blood brother to someone who commits a crime, and in some contexts you shared responsibility for helping pay compensation or restoring honor. The logic was that blood brotherhood made you partial guarantors of each other's behavior, so if your blood brother couldn't meet his obligations, you might be expected to help. This created additional incentive to choose blood brothers carefully. You weren't just gaining an ally, you were potentially assuming their debts and feuds. Blood brotherhood between men of vastly different social status was apparently less common, though not forbidden. You're a poor farmer swearing blood brotherhood with a wealthy chieftain, and while theoretically equal in the bond, practical reality meant the relationship looked more like patronage than partnership. The chieftain provided protection and resources, the farmer provided loyal service. Some historians argue this represents co-option of blood brotherhood traditions to reinforce social hierarchies rather than transcend them, turning egalitarian bonding rituals into tools of class distinction. You're standing on a rocky coastline watching a ship break apart in the surf, and while your first instinct might be humanitarian concern for the drowning sailors, your second instinctive, you're a Viking involves some very specific legal calculations about what you can legally claim from the wreckage. Maritime salvage law in Norse societies was surprisingly complex, balancing the practical reality that shipwrecks provided valuable resources with the moral understanding that profiting from others' disasters was ethically murky. The resulting legal framework created a detailed game of finders keepers with extensive rules about what counted as legitimate salvage versus theft from the dying. The baseline principle was straightforward. If you found wreckage washed ashore with no survivors or claimants present, you had salvage rights but with significant limitations. You're required to publicly announce your find, usually at the next thing assembly, and hold the salvaged goods for a specified period, typically a year and a day, that magic time frame again during which rightful owners or their heirs could claim them. If nobody came forward with legitimate ownership claims, the salvage became yours, though you often owed a portion to the local chieftain or landowner whose coastline the wreckage washed onto. The law recognized layered rights, finders' rights, landowners' rights, and original owners' rights all competed in a hierarchy that varied by region. Here's where it gets morally complicated. What about bodies? You're finding drowned sailors still wearing jewelry, carrying coins, maybe even clutching valuable cargo as they washed ashore. The law generally prohibited stripping corpses that crossed from salvage into desecration. You were supposed to give bodies proper burial and hold their personal effects for claiming by relatives. In practice, enforcement of this rule probably varied wildly based on whether anyone was watching and how badly you needed that silver armoring. Some legal codes specify penalties for corpse robbing that approach those for murder, suggesting the Vikings found it particularly distasteful. Other sources hint it happened regularly enough that warnings against it appeared necessary. The definition of wreck mattered enormously. You're looking at a ship that's damaged but still intact, grounded on rocks but potentially salvageable. That's completely different legally from a ship that's broken apart with cargo floating loose. Intact wrecks retained ownership rights more clearly. You couldn't just claim an entire grounded ship. You might salvage loose cargo washed free, but the ship itself and anything still aboard remained property of the owners or their heirs. This created incentives for swift salvage operations where owners tried to recover their property before tides and storms broke everything apart and scattered it along miles of coastline. The role of coastal landowners in salvage rights created a quasi-feudal system. You're a farmer whose land includes coastline, and local custom might grant you first rights to anything washed ashore on your property minus whatever portion you owed to higher authorities. This made coastal land particularly valuable in regions prone to shipwrecks, which is darkly pragmatic. Some sources hint that unscrupulous coastal dwellers deliberately created navigational hazards false signal fires, removed warning, marcasto, increased shipwreck frequency. Whether this was common practice or sensationalized saga material is debatable, but laws specifically prohibiting such wrecking activities suggest it happened at least occasionally. Historians still argue whether Norse coastal communities were primarily rescuers or opportunistic vultures. Rescue obligations complicated salvage rights. You're watching a ship in distress and you have the capability to help. Do you rescue the crew and cargo, or do you wait for the ship to wreck so you can claim salvage? The law tried to incentivize rescue by granting generous salvage rewards to those who saved ships and crews. You might receive a substantial portion of the cargo's value as reward for rescue, sometimes 1/3 or more depending on the danger involved. This was supposed to make rescue more profitable than waiting for disaster, though human nature being what it is, some people probably calculated whether rescuer or salvager rights offered better returns. The complications multiplied when dealing with cargo belonging to multiple owners. You're salvaging goods from a merchant vessel that carried products from dozens of different traders, each with partial ownership of specific barrels, bundles, or boxes. How did you even determine what belonged to whom after everything was soaked, scattered, and mixed together on the beach? The law required salvagers to maintain salvaged goods in identifiable condition when possible, and to keep detailed accounts of what was recovered. Merchants often marked their goods with specific symbols or seals, and these marks carried legal weight in ownership disputes. You couldn't just claim all this wool as generic salvage. If distinctive marks indicated it belonged to specific merchants, their ownership rights persisted. Deliberate scuttling created its own legal category. You're a ship owner facing certain capture by enemies or imminent wrecking in a storm, and you deliberately sink your own ship in shallow water where you or allies might later salvage the cargo. Did you abandon the property, making it legal salvage for anyone? Or did your intentional sinking constitute a plan to recover it later, meaning it remained yours? Legal precedents went both ways depending on circumstances. Some codes recognized that scuttling with intent to recover meant ownership persisted. Others treated deliberate sinking as abandonment, making salvage fair game. The ambiguity created litigation opportunities for anyone with good lawyer saw, in Viking terms, eloquent oath helpers. Livestock presented unique salvage challenges. You're finding horses, cattle, or sheep that swam ashore from wrecks, and they're definitely valuable, but also obviously living property with clear ownership markers. The law generally required you to maintain salvaged animals and make serious efforts to find their owners, because livestock weren't fungible commodities like barrels of grain. They had specific identities through brands, distinctive appearances, or known breeding lines. Keeping salvaged animals permanently was harder than keeping anonymous cargo, because animals could be identified and claimed years later. The spiritual dimensions of shipwreck couldn't be ignored in pagan Norse society. You're dealing with ships and cargo that might have been dedicated to particular gods or carried religious offerings, and claiming such property might bring supernatural consequences. Some sources mention that salvagers made offerings from their salvage to ensure they hadn't angered divine powers by profiting from disaster. Whether this reflected genuine belief or was just insurance policy thinking, better sacrifice 1/10 to Thor than risk the whole salvage being cursed, is unclear. Christians later reframed this as moral obligation to use salvage proceeds for charitable purposes, which served similar psychological functions. The timing of salvage claims mattered legally. You're the first person on scene versus arriving hours later after someone else has already begun salvage, completely different legal positions. First salvager typically had priority rights, with later arrivals needing to negotiate shares or assist the primary salvager. Some regions had informal salvage crews that rushed to wreck sites, operating almost like volunteer fire departments except motivated by profit rather than civic duty. These crews developed reputations, and repeated salvagers gained expertise that made them more efficient. They knew which cargo was most valuable, how to quickly assess structural safety, what could be recovered versus what was total loss. You're stepping away from the coastline with your salvaged goods and entering even stranger legal territory, the prosecution of sorcery and witchcraft in Viking society. Here's where Norse law confronted the supernatural directly, creating rules about proving someone cast harmful spells, what counted as admissible magical evidence, and how to legally respond when your neighbor allegedly cursed your crops using runes and goat entrails. The Vikings, despite their reputation for hard-headed pragmatism, absolutely believed in magic's reality and legal relevance. You couldn't just dismiss sorcery accusations as superstition. Courts took them seriously, examined evidence, however bizarre, and rendered judgments that could result in execution or outlawry for convicted practitioners. The type of magic mattered enormously. You're distinguishing between seether, a shamanic practice involving trance states, prophecy, and manipulation of fate, and other magical traditions like rune carving or herbal knowledge. Seether was particularly controversial because it was associated with feminine power and the god Freya's cult, making it shameful for men to practice. Remember those masculinity insults we discussed earlier? Calling a man a seithmathur, Seether practitioner, was fighting words because it implied he'd adopted women's roles. The legal codes reflected this gendered dimension. Women practicing seether might face accusations of harmful magic, but men practicing it faced additional shame for gender transgression. It's discrimination wrapped in supernatural terror, essentially. Accusations of harmful sorcery fylkingi required evidence. But evidence, in this context, meant things that would make modern prosecutors weep. You're proving your neighbor cursed you by pointing to circumstantial patterns. Your crops failed after you quarreled with her. Your livestock died mysteriously. You've had unusually bad luck since she muttered something while glaring at you. The law recognized that magic left no physical evidence like blood at a murder scene, so it accepted pattern-based arguments. If enough misfortunes clustered around interactions with the accused, that constituted suspicious activity worthy of investigation. Historians still argue whether anyone genuinely believed this logic or whether sorcery accusations were just convenient ways to eliminate rivals, but legal texts treat magical causation as legitimate. Witness testimony about magical activities carried weight. You're testifying that you saw the accused conducting strange rituals at night, chanting in unfamiliar languages, making offerings to questionable spirits, or possessing unusual objects like carved staffs or suspicious herbs. The accused person's reputation mattered too. If they were already known as practitioners of Setha, or had successfully predicted future events which proved magical knowledge, that history could be used against them in accusations of harmful magic. Being good at prophecy was legally dangerous because it established your magical capability, making harmful magic accusations more credible. The famous Nitstang curse poles we mentioned in the insult section had legal implications beyond just defamation. You're erecting a pole with horse genitals, runes cursing someone, and declarations that land spirits should abandon their property. That was legally actionable magical attack. The victim could sue for the curse pole's removal, demand compensation for spiritual damages and any misfortunes that followed, and in extreme cases argue that such magical assault justified violent self-defense. Some legal codes explicitly prohibited erecting nightstangs, treating them as serious offenses equivalent to physical assault. The Vikings understood that magical attacks, if you believed in them, could be as damaging as violence. Countermagic was legally tricky. You're the victim of alleged sorcery, and you hire another magical practitioner to break the curse or send it back to its originator. Is that legitimate self-defense, or are you now practicing illegal magic yourself? The Lord generally permitted defensive magic, Gulda, spells to protect against curses, runes carved for protection, rituals to cleanse cursed property. But the line between defensive and offensive magic could blur. If your defensive spell bounced the curse back and harmed the original caster, were you guilty of magical assault? Legal precedents went different directions depending on regional customs and specific circumstances. Execution methods for convicted sorcerers revealed deep fear of their power. You're being burned to death. Not hanged, not beheaded, but burned, which supposedly prevented the sorcerer's spirit from lingering and causing posthumous mischief. Other sources mention drowning in bogs, which served similar spiritual containment purposes. The special execution methods weren't just about punishment. They were magical prophylaxis against the convicted person's continued supernatural threat. It's like if modern courts not only imprisoned hackers but also ceremonially destroyed their computers to prevent digital hauntings. The Vikings took no chances with practitioners they deemed dangerous. The burden of proof in sorcery cases seems to have been surprisingly low. You're accused of witchcraft, and you can't easily prove a negative. How do you demonstrate you didn't curse someone's crops using invisible magical forces? This put enormous power in accusers' hands and created opportunities for abuse. Some sources suggest that unpopular people, particularly women who didn't conform to social norms, faced higher risks of sorcery accusations. Being old, ugly, socially isolated, or just weird made you vulnerable. The sagas mention several cases where sorcery accusations seemed transparently like pretexts for eliminating people the community found threatening or inconvenient. Interestingly, some magical practices were completely legal and even respected. You're a Volvaya female seer who travelled between communities performing prophecy ritual, and you commanded high social status. People paid well for your services, sought your predictions about harvests and fortunes, and treated you with respect, tinged with fear. The difference between respected vulva and accused witch often came down to whether your magic was used for communal benefit or private harm. Helping the community divine the future? Excellent, very legal. Cursing specific individuals because they annoyed you? That's when legal problems started. Intent and target mattered more than the magical practice itself. Rune carving occupied an ambiguous legal space. You're carving runes for protection, love, success in battle. Was that magic or just writing with spiritual significance? The law didn't clearly distinguish, probably because runic literacy itself seemed mysterious to most people. Some rune formulas were explicitly curse-related and therefore illegal when used for harm. Others were protective and acceptable. The carved medium matted tor runes on your own property were less suspicious than runes carved secretly on someone else's door or boundary stones. Location and visibility signaled intent, making public protective runes legal while hidden curse runes were prosecutable. Christianity's arrival transformed sorcery, prosecution. You're watching the church import new categories of demonic magic, devil worship, and heresy that didn't exist in pagan frameworks. Suddenly all magic became suspect, not just harmful varieties. The church argued that even beneficial magic involved trafficking with demons and therefore constituted sin worthy of punishment. This created conflict with Norse traditions that had accepted certain magical practices as normal. The transition period must have been confusing. Yesterday's respected seer practitioner became today's demon-consorting heretic, prosecutable under new theological frameworks that redefined what magic meant. What's darkly fascinating is how sorcery accusations became tools of social control. You're a powerful person who wants to eliminate a rival, and accusing them of witchcraft provides a socially acceptable path to their destruction. The accused person's actual magical practices might be irrelevant. The accusation itself, if supported by enough oath helpers and suspicious-looking evidence, could be sufficient. This parallels witch trials in later European history, suggesting that legal prosecution of supposed supernatural crimes often serves very worldly political and social functions. Vikings might have believed in magic's reality, but they also understood how to weaponize those beliefs for mundane purposes. You're navigating Viking society and realizing that your most valuable asset isn't your land, your silver, or your sword, it's your reputation. In a world without credit scores, background checks, or Yelp reviews, your standing in the community determined whether people would trade with you on credit, swear oaths supporting you in legal disputes, let their daughters marry you, or trust you with borrowed tools. Reputation functioned as invisible currency that enabled or prevented nearly every transaction and interaction. You couldn't just move to a new town and start fresh. Viking society was interconnected enough that your reputation traveled faster than you did, carried by traders, travelers, and that most powerful of Norse institutions, the gossip network. The gossip network was sophisticated information infrastructure disguised as casual conversation. You're sitting at a feast, and while people appear to be making small talk, they're actually conducting high-stakes intelligence gathering. Who honored their debts? Who cheated in trades? Who backed down from challenges? Who helped neighbors during crisis? Every interaction generated data points that got shared, evaluated, and incorporated into your reputation score. Women particularly excelled at this information management, while men were off raiding or attending things. Women maintained the social networks that determined who could be trusted. Historians still argue whether women's gossip power translated into formal legal influence, but there's no question it shaped community decisions about reputation. The mechanics of reputation building were surprisingly quantifiable. You're establishing yourself in a community through a series of small trust-building exercises. You borrow a tool and return it promptly in good condition. You make a trade and deliver exactly what you promised. You help a neighbor with harvest and refuse payment. Each successful interaction deposits credibility into your reputation account. These small deposits accumulated over years into substantial social capital you could draw on when needed. Conversely, one major violation, cheating in a significant trade, failing to pay substantial debt, backing down from legitimate honor, challenges could bankrupt your reputation instantly. The system was harsh but clear. Your reputation determined your access to credit and trade. You're a merchant trying to conduct business, and if you had a reputation for honesty, people would extend credit, accept your word about product quality, and trust you to deliver goods months later. Poor reputation meant you'd need to pay cash up front and possibly provide collateral for even small transactions. Some traders apparently carried reputation vouchers, basically letters from respected people in their home communities testifying to their trustworthiness. It's like medieval LinkedIn recommendations, except the stakes were higher and lying had actual consequences. If you vouched for someone who turned out to be dishonest, your own reputation took damage. The concept of honor debt created complex webs of obligation. You're tracking not just financial debts but social debts, who helped you during hardship, who insulted your family, who swore oaths supporting you, who refused assistance when asked. These debts demanded eventual repayment, those who helped you, avenging insults, supporting oath helpers when they needed you. Failing to repay honor debts damaged your reputation more severely than defaulting on silver debts. The sagas are full of characters whose reputations collapsed because they failed to avenge family members or refused to help former allies. You could theoretically go bankrupt financially and rebuild, but honor bankruptcy was often permanent. Reputation functioned as law enforcement without police. You're considering cheating someone in a trade deal, but you know that if discovered, word would spread through gossip networks within days. Future trade would become difficult or impossible. People would refuse to swear oaths supporting you in legal disputes, and you'd struggle to arrange marriages for your children because nobody wanted to ally with dishonest families. The threat of reputation damage deterred many potential violations more effectively than formal punishment could. Why steal when the long-term reputation cost exceeded the short-term gain? Of course, this system only worked when you planned to remain in the community. Traveling raiders or one-time visitors had less incentive to maintain reputations, which is why legal protections for transactions with strangers were particularly strict. Gender created different reputation currencies. You're a man building reputation through martial prowess, successful raids, generous hospitality, and honoring oaths. You're a woman building reputation through household management, strategic marriage alliances, supporting family interests, and wielding influence over gossip networks. Both mattered, but they operated in somewhat separate spheres. A man with poor martial reputation but excellent trade reputation occupied different social space than a renowned warrior who was lousy at commerce. Women's reputations were particularly vulnerable to sexual scandal. Accusations of adultery or promiscuity could destroy female reputation even if unproven, while male sexual behavior faced looser standards. The double standard was obvious and oppressive. The system had built-in mechanisms for reputation repair after minor damage. You're recovering from a reputation hit by publicly acknowledging the mistake, making appropriate compensation, and then consistently demonstrating reformed behavior. Some people apparently hired respected community members as reputation sponsors who vouched for their reform, essentially character witnesses who staked their own reputation on your rehabilitation. This created incentive structures where sponsors closely monitored your behavior because your failures reflected on them. It's mentorship with mutual accountability built in. Reputation could be inherited both positively and negatively. You're born into a family with excellent reputation, and you started life with social advantages. People extended you trust and opportunities based on your family's standing. Conversely, being born to dishonored parents meant you began with reputation deficits you'd need years to overcome. Some families maintained high reputations across generations, becoming de facto aristocracy based on accumulated social capital. Other families fell into reputation poverty that persisted for generations, creating quasi-caste systems based on honor rather than formal legal status. The vulnerability of reputation-based systems became apparent during times of rapid change. You're living through periods of migration, Christian conversion, or political upheaval when old certainties collapsed and reputation networks fragmented. When communities fractured or people moved to new settlements, the gossip networks that maintained reputation information broke down. This created both opportunity and danger. You could escape bad reputations by moving to frontiers like Iceland where your past was unknown, but you also couldn't rely on established reputations to identify trustworthy partners. Iceland's settlement period saw both benefits and challenges of this reputation reset. Reputation could also be weaponized through deliberate character assassination. You're spreading false rumors about a rival, undermining their standing through coordinated gossip campaigns, or selectively sharing negative information while suppressing positive context. The Vikings recognized this as evil speech, ilkvafi, and some legal codes permitted suing for slander when false statements damaged reputation. But proving statements were false versus just unflattering was difficult, and by the time legal proceedings resolved, the reputation damage was done. It's like trying to unring a bell, possible in theory, impossible in practice. What made the reputation system effective was its integration with everything else in Viking law. You're discovering that reputation wasn't separate from legal proceedings, it was foundational to them. Your ability to gather oath helpers depended on reputation. Your credibility as a witness depended on reputation. Your success in negotiations, trade deals, marriage arrangements, and essentially every social interaction was filtered through reputation. The Vikings had accidentally created a distributed peer-to-peer enforcement system where everyone monitored everyone else and consequences emerged organically from collective judgment rather than top-down authority. It was remarkably efficient, if occasionally brutal to individuals caught on the wrong side of public opinion. You're stepping back from all these weird rules. The nose cutting, the oath helpers, the 3-warning system, the livestock trials, the salvage games, and asking the fundamental question, did any of this actually work? The surprising answer is yes, remarkably well, at least for the people who designed it. Viking legal systems maintained relatively stable societies across Scandinavia and the North Atlantic for centuries without professional judges, police forces, prisons, or most of the apparatus we consider essential to justice. Understanding why these strange mechanisms succeeded reveals something profound about law itself. It's not the rules that matter most, but whether people believe in them and whether the community enforces them. The genius of Viking law was its integration into daily life rather than separation from it. You're not dealing with a distant legal system administered by strangers in courtrooms you'll never see. Instead, justice happens in the thing assembly, where you know every participant, where your neighbors serve as judge and jury, where your own reputation and relationships determine outcomes. This proximity created powerful accountability. You couldn't hide behind bureaucracy or hope the system forgot about you. Everyone knew your legal status, your debts, your feuds, your obligations. The transparency was oppressive, but also remarkably effective at enforcing compliance. You behaved well not because police were watching, but because everyone was watching, all the time. The flexibility of Viking law allowed it to adapt to local circumstances without losing coherence. You're living in coastal Norway versus landlocked Iceland versus the Scottish Islands. And while core principles remained constant wordchild for injury, outlawry for serious crimes, thing assemblies for adjudication, the specifics adjusted to local needs. Coastal communities emphasized maritime law. Farming regions focused on property and livestock disputes. Trading centers developed commercial regulations. This flexibility prevented the system from becoming rigid and irrelevant. Modern legal systems often struggle with one-size-fits-all approaches that ignore local contexts. Vikings avoided this by making customization fundamental rather than exceptional. The graduated consequences, hose warning systems, the multiple paths to dispute resolution, the flexibility between compensation and outlawryment, the legal system could respond proportionally to offences. You're not facing the death penalty for minor theft or watching serious criminals escape with token fines. Instead, the system scaled responses to match both offence severity and offender history. First-time mistakes received lenient treatment, repeated violations triggered escalating consequences. This prevented both excessive harshness that would alienate communities and excessive leniency that would invite chaos. Modern three-strikes laws and sentencing guidelines attempt similar calibration, often less successfully because they lack the Viking system's contextual flexibility. The integration of honor, reputation, and material consequences created multi-layered enforcement. You're deterred from wrongdoing not just by legal penalties, but by shame. social exclusion, and damage to your family's standing. Vikings understood that humans respond to multiple incentive structures. Simultaneously, financial pain, social pain, and threats to physical safety all worked together. Modern legal systems often rely too heavily on single enforcement mechanisms, imprisonment, fines, and wonder why they're insufficient. Vikings accidentally discovered that combining material consequences with social and reputational ones created more robust deterrence. What Vikings lost in systematization, they gained in community investment. You're personally involved in legal proceedings, not as passive defendant or spectator, but as active participant whose social capital was on the line. Your oath helpers, your reputation, your eloquence, all mattered. This participation created buy-in. People respected legal outcomes more when they'd actively shape them rather than having strangers impose verdicts. Modern jury systems attempt similar participation, but within much more constrained roles. Vikings gave ordinary people more agency in legal proceedings, which increased legitimacy even when outcomes seemed harsh. The system's remarkable efficiency came from minimizing administrative overhead. You're not supporting massive court systems, prison infrastructures, or professional legal classes. Instead, the Thing Assembly met periodically, resolved disputes through community involvement, and then everyone returned to productive activities. Outlawry removed problematic people without imprisonment costs. Wergild compensated victims without expensive prosecution. The whole system ran on minimal resources because it leveraged existing social structures rather than creating parallel bureaucracies. This efficiency meant communities could maintain justice without dedicating substantial portions of their economies to legal administration. Of course, the system had massive flaws that modern societies rightly rejected. You're wealthy and well-connected, and justice tilted heavily in your favor through better oath helpers, more resources for compensation, and greater ability to withstand reputational attacks. Poor, isolated, or foreign individuals faced systematic disadvantages that made equal justice impossible. Women's legal status, while better than in many medieval societies, still reflected patriarchal assumptions. Slavery existed within the system, creating legal contradictions the Vikings never resolved. The reliance on reputation meant that unpopular people received harsher treatment regardless of actual guilt, and the threat of violence, holmgang, outlawry, revenge, killings pervaded everything, creating constant danger that modern societies work hard to eliminate. What modern legal systems gained through professionalization, standardization, and separation from community passions came with costs Vikings never paid. You're experiencing justice as something done to you by distant authorities rather than with you through community participation. Legal proceedings become incomprehensible performances in specialized language that excludes ordinary people. The system's complexity requires expensive professional intermediaries, lawyers, judges, court administrators that price many people out of effective access. Most importantly, modern justice lost the tight feedback loops between behavior, reputation, and community standing that made Viking law self-enforcing. We've gained fairness, consistency, and protection from mob justice. But we've lost something too, the sense that justice belongs to the community rather than to the state. The Vikings solved the fundamental problem of maintaining social order without centralized power through a brilliantly simple approach. They made everyone responsible for everyone else and created systems where self-interest aligned with community interest. You benefited from honest behavior, from maintaining good reputation, from resolving disputes peacefully, because the alternatives, outlawry, social exclusion, constant feuding, were worse for everyone. It wasn't perfect, it wasn't fair by modern standards, and it depended on social cohesion that larger, more diverse societies can't maintain. But it worked in its context for its people. And now, as we reach the end of this strange journey through Viking legal codes, let yourself settle deeper into comfort. These ancient solutions to timeless problems show to live together, how to resolve conflicts, how to build trust among strangers, continue echoing in courtrooms and communities today, even if the methods look different. No more nose-cutting or Homgang duels, thankfully, but the underlying questions persist. What makes law legitimate? What creates justice? How do we balance individual rights against community needs? Let the details fade now. The Were-Guild calculations, the oath-helper mathematics, the specific procedures for boundary disputes. What remains is something simpler, the recognition that humans have always struggled with these questions, have always sought frameworks for living together peacefully. The Vikings, with all their violence and contradiction, at least tried to create systems that worked for their world. That effort, however flawed, connects across centuries to our own attempts at justice and order. Your breathing is slowing, your thoughts drifting like salvaged cargo washing gently onto a quiet shore. The thing assemblies have adjourned, the oath helpers have returned home, the outlaws have vanished into their forests. What seemed important, the specific regulations, the categories of insult, the precise boundaries between properties, dissolves into the soft haze of approaching sleep. You're left with only the gentle rhythm of history repeating its essential patterns, conflict and resolution, injury and compensation, chaos, and the human determination to create order from it. The Vikings are sleeping now too, along with their strange laws and stranger solutions. Their voices fade into the distance of centuries, leaving you alone with the quiet darkness and the soft certainty that tomorrow's problems will find tomorrow's solutions, just as theirs did. Rest now. Let it all go. Drift away into dreams where no legal complications can follow. The journey is complete.